Morning.
Morning.
8:30.
Just to make sure. I do not see a Rajala Hall in the Zoom courtroom. I do not see Rajala Hall in the physical courtroom. Uh, All right, Mr. Kaminsky, we'll go on your case.
All right.
But we're getting some feedback from you, so stand by with.
Okay.
All right, so we're on the record in docket 23-02741. That is People of the State of Michigan versus John Kaminsky. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Freeman.
Good morning, Your Honor. Stephen A. Freeman, Assistant Public Defender, on behalf of Mr. Kaminsky, who joins us, I think, by Zoom.
Right. And sir, you are John Kaminsky, is that correct?
That is correct.
All right. You can hear me all right, Mr. Kaminsky?
Yep, I can hear you just fine.
All right, perfect. Thank you. This is the time set for probable cause conference. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe we're going to leave this set for exam next week. We did receive a appearance from Mr. Freeman early this week, but have not had an opportunity to get discovery over to him. I anticipate our discovery unit will get that over to him shortly, and I will relay an offer. If we don't need to do it right, because I know Mr. Kaminsky is currently in MDOC, we'll let the court know ahead of time.
Where is he in? Is in Coldwater?
That's my understanding, I believe.
Right.
Yeah.
Is that a fair statement, Mr. Freeman?
It is, Your Honor. Thank you.
All right, so we're going to leave this on for July 11th, 2024 at 8:30 for discovery to be provided to counsel who just filed an appearance. And then we may or may not rip you out of Coldwater for that date, Mr. Kaminsky. All right, sir?
Okay, that's fine.
All right. Anything else for the record at 23-02741? Ms. Wilson.
Not for the people. Thank
Mr.
you.
Freeman.
No, Your Honor. Thank you.
Thank you. You're all set, Mr. Kaminsky. Thank you for your appearance today.
All right, thank you.
And then while Mr. Freeman's up, I believe he has Miss Curtis and Miss Smith is on Zoom to handle that file as well.
So, Curtis.
Yes, I'm here for Miss Curtis.
So we're on the record in docket 24-01008. That is People of the State of Michigan versus Zoe Curtis. Will the parties please introduce themselves to the record? Ms. Smith.
Thank you, Your Honor. Good morning, Assistant Prosecuting Attorney Melanie Smith for the people.
Mr. Freeman.
Yes, Your Honor. Stephen A. Freeman, Assistant Public Defender, on behalf of Ms. Curtis, who joins us via Zoom.
And ma'am, you are Zoe Curtis, is that correct? Which one is she on Zoom?
You got a hotspot on here?
All right, so ma'am, you are Zoe Curtis? You have to unmute. Ms. Smith, do you see a Miss Zoe Curtis here? I don't know if you know what she looks like.
Your Honor, there's only one female that I see that has their camera on, and nobody has their name labeled as Miss Curtis.
Right.
Fortunately, I don't know what Miss Curtis looks like.
Yes.
If I may, I think the woman on the screen is Rebecca Williams.
This
Hello?
So on the iPhone 3 in the black top, what could you please identify yourself, and you have to unmute because we have you as muted.
Can you see it? Oh.
With the black top and a bun.
Yes,
Oh, there you
I'm sorry. I've never done Zoom before and it was hidden. I'm Rebecca.
All right. So ma'am, you are Zoe Curtis. Is that correct?
No, I am Rebecca Williams.
Well, thank you. So you are Rebecca. Is Miss Curtis here? All right. So let's identify everybody while we can. So that's Rebecca. What was her last name? Williams?
Yes, Williams.
Perfect. All right, and then on the iPhone, would you please identify yourself? You're on an iPhone. You're labeled iPhone. You have to unmute.
Hello,
Yeah, what's your name?
Sienna Jordan.
And you're Sienna Jordan?
Yes.
And what's your case number? Are you on Judge Buchanan's docket or my docket?
I'm sorry, could you repeat that?
Are you on Judge Flores' docket or Judge Buchanan's docket?
I did not hear you.
Are you on Judge Flores' docket or Judge Buchanan docket?
Could you ask the
Ms.
question
Jordan,
again?
I don't have you on either docket. I don't have a Jordan on either docket.
I called. That's
Well, what's your name?
CYANNA
Sienna?
JORDAN.
And what's your last name?
Jordan.
Yeah, I don't have a Sienna Jordan on either Judge Buchanan's docket or Judge Flores' docket.
Okay.
So you don't need to be here today.
Okay.
At least.
Is she a victim?
Are you a victim, a witness, a defendant? What did you think your case was?
A
I
defendant.
don't know if she knows.
I don't recognize the name at all, so I'm not entirely sure.
All right,
myself.
Ms. Jordan, I don't think you're in the right courtroom.
Your Honor, I just looked for that
Okay.
name in our database. It doesn't look like she has a case with the county prosecutor's office. Maybe she has a city case.
Ms. Jordan, I don't know if you're in the right courtroom.
Okay.
Thank
Sorry
you.
about that. Okay, thank you.
And then we're back on the record in 24-01-008. I don't see Miss Curtis. Is there a Miss Curtis in the physical courtroom? And I don't see a Miss Curtis in the Zoom courtroom. This was set for 8:30. It's now. It was set for 8:30. It is now 8:57. Ms. Smith, how did you want to proceed on Ms. Curtis's probable cause conference?
Your Honor, I'm inclined to request that we set next week's preliminary exam date on as a secondary PCC to allow Mr. Freeman some time to try and get in contact with Ms. Curtis rather than issuing a bench warrant today. She has very minimal criminal history, and I'm hoping that today is simply just a miscommunication or a lapse in memory of today's date.
Okay, is that a fair statement, Mr. Freeman? We'll set this on for PCC for next week. That would be July 11th to give some time to contact Ms. Curtis, not bench warrant.
Yes, Your Honor, I agree. Thank you.
All right. We'll leave on and we'll make that. We'll leave on and we'll make it a PCC for July 11th at 8:30, and then we'll go from there.
Thank you, Ms. Smith.
All right. Anything else
Mr.
for the
Freeman.
record in 24-01-008? Ms. Smith.
No, Your Honor, thank you.
Mr. Freeman.
No, Your Honor. Thank
All right,
you.
you're all set. Thank you for your appearance today. All right, let's do Mr. And then Mr. Freeman, you have one. That is
Ms.
Ms.
Carr.
Carr. Okay.
Thank you.
Right, so we're on the record in docket 24-01-791. That is the people of the state of Michigan versus Emily Carr. Will the parties please introduce themselves for the record?
Hi, Your Honor.
Is Mr. Nagel here
Yes.
on Carr?
Don't have a car on my docket.
At 8:45?
It's not on my docket, but I'm here.
All right. All right. Mr. Nagel, your appearance for the record.
Matt Nagel for the people.
All right, Mr. Freeman.
Stephen A. Freeman, Your Honor, Assistant Public Defender, on behalf of Ms. Carr, who is standing to my right.
Ma'am, you are Emily Carr, is that correct? All right, thank you. This is the time set for a probable cause conference in front of Judge Buchanan. Mr. Nagel, would you like to defer to Mr. Freeman concerning what we're doing today?
I'll defer to Mr. Freeman, although I imagine we're leaving this up for example.
All right, Mr. Freeman.
Yes, Your Honor, thank you. With the pleasure of the court, we would respectfully allow the court to continue this to preliminary examination. We'd like to go forward with the hearing at that time.
All right, so I'll leave on for preliminary examination in front of Judge Buchanan at 9 a.m. That'll be on July 11th at 9 a.m. in front of Judge Buchanan. So a week from today, I think. That is a week from Thursday. So next Thursday at 9 a.m. Anything else for the record in 2401791, Mr. Nagel?
No, Your Honor, thank you.
Mr. Freeman?
No, Your Honor, thank you.
All right, so you'll be in front of Judge Buchanan at 9 o'clock next week. All right, ma'am? Thank you.
My thanks to the court.
Thank you, Mr. Freeman.
Your Honor, is there just the one file for Ms. Carr?
Yes.
Okay. Maybe somewhere else.
And you said Ms. Smith was on another case?
Mr. Eskin, Your Honor, he's in custody.
Mr.
I got
Eskin.
Mr. Eskin and also Mr. Moore here, so we can clear out a couple of the in custody folks.
So let's do Eskin first. That's on Buchanan's docket. All right, so we're on the record in docket 2401936. That is people of the state of Michigan versus Keith Richard Eskin. Will the parties please introduce themselves to the record? Mr. Nagel.
Actually,
For Mr.
Oh, that's
Eskin,
Ms.
Your
Smith.
Honor.
Yeah, that's,
Yes, thank you so much. Assistant Prosecuting Attorney Melanie Smith for the people.
and Mr. Sarks.
Good morning, Your Honor. Jacob Sarts, the fourth Assistant Public Defender here on behalf of Mr. Eskin. I'm appearing in person. Mr. Eskin's appearing by Polycom from the Ingham County Jail.
And sir, you are Keith Eskin, is that correct?
Yes,
All right, you can hear me all right, Mr. Eskin?
yes, Your Honor.
All right, thank you. This is the time set for probable cause conference in front of Judge Buchanan. Ms. Smith, how are we proceeding today?
Thank you, Your Honor. Mr. Eskin has several files pending in the 30th Circuit Court as well. So at this time, there's not going to be an offer made at the district court level. I believe we are leaving this set for preliminary exam next week, and the people will be prepared to proceed at that time.
Is that your understanding, Mr. Sarks?
That's correct, Your Honor. We have discovery. We'll be ready to proceed next week.
All right, so we'll leave this on for July 11th at 9 a.m. in front of Judge Buchanan. Anything else? So we're leaving this on July 11th at 9 a.m. in front of Judge Buchanan. Anything else for the record in 2401936, Ms. Smith?
Nothing from the people. Thank you.
Mr. Sarks?
Nothing from the defense at this
Oh,
time, Your Honor.
All right, Mr. Eskin, you'll be in front of Judge Buchanan next Thursday at 9 a.m. Thank you for your appearance today.
Thank you, Your Honor. Have a great weekend.
Thank you, Ms. Smith. And then who else did you have, Mr. Sarks?
Mr. Emil Moore is also here. He's in post 2, visit 4.
All right, Emil Moore.
Yes.
Mr. Moore?
Yeah.
So we're on the record in docket 2401726. That is people of the state of Michigan versus Emil Moore. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Sarks.
Good morning, Your Honor. Jacob Sarts, the fourth Assistant Public Defender, appearing in person on behalf of Mr. Moore. Mr. Moore is appearing by Polycom from the Ingham County Jail.
And sir, you are Emil Moore, is that correct?
Yes, sir.
All right, thank you. And you can hear me all right, Mr. Moore?
Yes, I can.
All right, this is the time set for a probable cause conference Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding we're going to leave this set for exam next week.
And that's a fair statement, Mr. Sartz?
That's correct, Your Honor. We have discovery. We'll be ready to go next week. Thank you.
So we've set for preliminary exam on July 11th at 8:30. So, Mr. Moore, we've held the probable cause conference, and the preliminary examination will be left on for July 11th at 8:30. Anything else for the record in docket 2401-726, Ms. Wilson?
Not for the people. Thank you.
Mr. Sartz?
Not for the defense at this time, Your Honor.
All right,
Thank you.
Mr. Moore, we'll see you next Thursday at 8:30. Thank you for your appearance today.
Thank you, everyone.
Thank you, Mr. Sartz.
Is that an Iowa?
No, it's Ingham County. Steve's in jail, I went to jail for whipping a
All right,
shit out of
Mr. Russell, everybody in the courtroom can hear you, so you might want to mute.
Judge,
That's-
Mr. Johnson told me he had Zoom for Judge Babcock
Okay.
and would be back.
He'll be back.
Okay, Steve.
Let's go on, Mr. So, Mr. Kukulka, we'll call your case. We're on the record in docket 2401-897. That is people of the state of Michigan versus Stephen Kukulka. Will the parties please introduce themselves for the record? Mr. Nate.
Good morning, Your Honor. Matt Nagel for the people.
And Mr. Lincoln, you represent Mr. Kukulka today?
Yes, Your Honor, Bruce Lincoln on
Right.
behalf.
Your appearance for the record, please.
Bruce Lincoln on behalf of Stephen Kukulka.
I'm sorry, I didn't hear that. Mr. Lincoln, you're gonna have to say it again.
Bruce Lincoln on behalf of Stephen Kukulka.
Perfect. And sir, you are Stephen Kukulka, is that correct?
That's correct.
All right. You can hear me all right, Mr. Kukulka?
I can hear you.
All right, thank you. This is the time set for a probable cause conference. Mr. Naga, how are we proceeding today?
I have not had an opportunity to speak with the defense counsel on this, but I imagine we are going to just leave this set for preliminary exam, which is currently scheduled for Thursday, July 11th at 8:30.
Is that a fair statement, Mr. Lincoln?
Your Honor, I haven't had the opportunity to go over the discovery with my client, so I don't know if that's an accurate statement.
But I think Mr. Nagel has just indicated that we're leaving it on.
I would like this reset for another probable cause hearing because Stephen may be willing to do something. I don't know.
I have no objection to an adjournment if that's what council's looking for.
All right. So there's no objection. I can adjourn the matter for Judge Buchanan, but Judge Buchanan would have to take a waiver of the 21-day rule.
That's fine.
All right. So let's do that. All right. So Mr. Lincoln, may I inquire of Mr. Kukulka and explain to him what a waiver of the 21-day rule means?
Say again.
May I make inquiry of your client to explain to him the waiver of the 21-day rule?
Yes, Your Honor, I've done that.
Thank you.
Prior to the hearing.
All right. So Mr. Kukulka, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Bruce Lincoln, and he would be present at that preliminary examination to contest any charges or cross-examine any witnesses brought against you by the people of the state of Michigan. It is my understanding it is your request to waive your right to a prelim only within that 21-day period and have me set it for preliminary examination outside of that period to give Mr. Lincoln some time to get discovery, to discuss discovery with you, and then to represent you in a preliminary examination. Mr. Kukulka, is it my understanding it is your wish today to waive your right to a prelim outside of that 21-day period? You won't be waiving your right to a prelim in general.
Yes.
Okay. So I find, and Mr. Nagel, you also waive the people's right to a prelim within 21 days.
We do, Your Honor.
All right. We will wait. So I'm going to take the waiver of the 21-day rule. And then we can set it out for now that we can set it out to, we have some dates that Buchanan gave us. Mr. Lincoln, does August 1st at 10:45 work for a new probable cause conference?
Yes, Your Honor, that does.
All right. So we'll set it for August 1st at 10:45. And that'll be set for PCC for negotiations to continue. And you have that date, Mr. Nagel?
I do, Your Honor.
Okay. Anything else for the record in 2401897, Mr. Nagel?
Nothing from the people.
Mr. Lincoln, do you have any questions of me? This will be set for August 1st at 10:45 in front of Judge Buchanan.
Yeah, have it in my calendar. Thank you, Your Honor.
Thank you. You're all set, Mr. Kukulka. We'll see you on August 1st at 10:45. You'll be in front of Judge Buchanan. Thank you for your appearance today.
Thank you, Your Honor.
Your Honor, I only have two more.
All right, so we're on the record in docket 2401721. That is people of the state of Michigan versus Rebecca Williams. Will the parties please introduce themselves for the record? Mr. Nagel.
Good morning, Your Honor. Matt Nagel for the people.
Mr. Coons.
Good morning, Your Honor. Dustin Coons for Rebecca Williams. I'm here in person. She's on Zoom.
And ma'am, you are Rebecca Williams, is that correct?
Correct.
All right, thank you. Yeah, and you can hear me all right, Miss Williams?
Yes.
All right, this is the time set for a probable cause conference. Mr. Nagel, how we proceed?
It's my understanding the defense counsel is going to be seeking an adjournment. We won't object to that request. He was just recently retained, and there is a large volume of discovery on this.
All right, and so Mr. Coons, you're looking for, is that a fair statement?
That's right, Your Honor. There were 71 videos. I was just in trial plus the holiday, so we'll need a little bit more than a week, I think, to be prepared for preliminary exam.
All right, and is your client at this time willing to waive the right to a prelim within 21 days so you can look at all the information and get ready for prelim?
She is. We discussed what that entails this
All
morning.
right. May I inquire of your client of their 21-day waiver of the prelim within 21 days?
Yes, please, Your Honor.
All right, thank you. All right, Ms. Williams, you can unmute. And I'm gonna, so it is my understanding it is your wish and intent to waive your right to a prelim within 21 days of your date of arraignment. You'll only be waiving your right to a prelim within that 21-day period. You won't be waiving your right to a prelim in general. It's my understanding that the preliminary examination is a probable cause hearing that the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Dustin Kuntz, and he would be responsible for cross-examining any witnesses or contesting any charges brought against you by the people of the state of Michigan. It is my understanding that Mr. Kuntz was just retained on the case, and there's a lot of discovery in the matter, police reports and et cetera. And so he wants to review all that in order to zealously represent you at that preliminary examination. Is it my understanding it is your wish today to waive your right to a prelim within that 21-day period, have it adjourned outside of that 21-day period, so Mr. Coons can get all the information he needs to zealously represent you? Is it your wish today to waive your right to a prelim within 21 days?
Yeah.
And the people also waive their right to a prelim within 21 days?
We do, Your Honor.
I find the 21-day rule to be knowing, voluntarily, and accurately made, the waiver of that, and we will set this. So do you want to set this for another PCC?
I think that could be helpful in this case. Your Honor.
So we'll set for PCC for negotiations to continue, and for discovery, just to see if there's any other discovery out there. And what date do you have? Judge Buchanan gave us dates.
Yeah.
So. August 1st at 10?
That works, Your Honor.
All right. We'll set it for August 1st at 10 o'clock. So, Ms. Williams, we've reset your probable cause conference for August 1st at 10 o'clock. Anything else for the record in 2401721, Mr. Nagel?
No, Your Honor, thank you.
Mr. Coombs?
No, thank you, Your Honor.
All right. All right, Ms. Williams, you're all set. You'll be in front of Judge Buchanan on August 1st at 10 o'clock. All right, ma'am?
Thank you. Have a great weekend.
You too. You're all set.
Bye.
And then Mr. Reyes?
Mr. Reyes would be the last one.
That'll be the last one. And that's your client, Mr. Austin?
It is, Your Honor.
All right. All right, so we're on the record in 2401898. That is people of the state of Michigan versus Jesse Reyes. Will the parties please introduce themselves for the record? Mr. Nagel.
Good morning, Your Honor. Matt Nagel for the people.
Mr. Austin.
Thank you, Your Honor, and good morning. Jared Austin appearing on behalf of and in the absence of Mr. Reyes.
All right, this is the time set for a probable cause conference. It was set for 8:15 today. Mr. Nagel, how are we proceeding?
People are going to request a bench warrant, Your Honor.
All right. I do not see a Mr. Reyes in the Zoom courtroom. Is there anybody of that name in the physical courtroom? Based on counsel's representations, it would appear that the defendant has failed to appear. We'll check just in case. We'll check the waiting room. It would appear that Mr. Reyes has failed to appear for the probable cause conference. Mr. Nagel, you're requesting a bench warrant and bond forfeiture?
Yes, Your Honor.
Mr. Austin, response.
Yes, thank you, Your Honor. I don't have any explanation for Mr. Reyes's absence. I know we've made attempts at all the means that we have to communicate with him to reach him. We have not received any responses from him. As to his whereabouts or non-attendance, unfortunately, I can't provide the court with his whereabouts or his intentions.
So you had no contact with Mr. Reyes on the file?
I have not, Your Honor. We sent a letter to the address that he provided us on file. We have not received a response to that letter. I have made numerous attempts to call him at the phone number that he provided us with. I have left multiple voice messages on that phone number. I have not received any responses from that, nor any responses from someone from that number saying that that's not his number. He did not provide us with an email address. As far as I could tell, he did not appear to be in custody anywhere else, Your Honor. So unfortunately, that's all the information I can provide the court at this time.
I don't have him in custody on date of arraignment. So we'll issue a bench warrant and bond forfeiture. This is an assault of crime on 2 counts, so it is issued without a 48-hour hold. Anything else for the record in 2401898, Mr. Nagel?
No, Your Honor. Thank you.
Mr. Austin.
Just, Your Honor, do we have any way of knowing is Judge Buchanan's Zoom courtroom being monitored, just in case he appeared there?
It is being monitored. It's my understanding that nobody's appeared there yet, but we can take that into consideration if he if he showed up for whatever reason. But at this time, we don't have any indication that he's appeared at Judge Buchanan's Zoom monitoring courtroom.
With that, Your Honor, I have nothing further about Mr. Reed.
All right, thank you. You're all set.
That does it for Judge Buchanan's document.
All right,
Thank
Mr.
you very
Nagel,
much for
thank you.
hospitality.
You're all set. And Mr. Palmer's here.
I am here.
On Gonzalez.
I'm Gonzalez and Evans, I believe.
Evans, yeah.
And are you on both?
Yes.
All right.
Yes, I have Mr. Gonzalez and Mr. Evans.
All right.
Is Mr. Johnson back?
Mr. Johnson is not back yet.
So I think we should probably wait to call the Gonzalez until he's back. I think we're ready on Agueros. It's set for a prelim, but it's not gonna be a prelim.
All right.
I'm gonna go try, Judge, I'm gonna try to find my client, Mr. Evans.
All right.
Well, he was not in custody on this case and he was supposed to be released yesterday from the jail.
Oh, I had him still in custody yesterday.
We have him highlighted. Is Mr. Evans in custody?
That's obvious.
PR.
Oh.
That's the thing I can't figure out. He had a PR bond on this file. He was held on a child support case, but his out date was July 4th. So I don't know if he's downstairs. He's not in the hallway. I can tell the court that.
All right. I'll tell you what the computer says. Evans, Brandon Evans.
He's incarcerated, Judge. He's still showing on the county roster.
So we still have him this morning on the county roster.
Okay, I have no idea why, but if that's the case, we'll wait.
So we'll go on to Agueros.
Yep.
And then, all right. And then we know where Mr. Palmer is, and we're just waiting on Mr. Johnson. But Mr. Palmer, you can leave and we'll know where to find you.
Certainly, Judge. I'm just gonna run down and talk to you.
All right, because I know you're gonna be in this hallway.
Not leaving.
All right, so we're on the record in docket 24-01499. That is people of the state of Michigan versus Calvin Agueros. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Feigelson.
Yes, Your Honor. Good morning, Assistant Public Defender Stephen Feigelson on behalf of Calvin Agueros, who's standing to my right this morning.
And sir, you are Calvin Agueros, is that correct? All right, thank you. This is time set for preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. At this time, the people would be moving to dismiss count one. That's the assault with intent to do great bodily harm less than murder or by strangulation. The remaining misdemeanor counts would remain, and we'd be requesting that this be set for a pretrial. And I do have a record I would like to make once we get the administrative issues figured out.
So this is a dismiss of count one, which is the assault GBH. The felony count, and then counts 2 and 3 will be set for pretrial. Is that my understanding?
That's correct, Your Honor. Thank you.
Mr. Feigelson, is that your understanding today?
It is, Your Honor.
All right. So we will print out a nollie cross on the count one. And then Ms. Slaviak, I'll have that. Does that have to go? I mean,
Yep.
thank you. And I will sign the nollie pros on count one. I'm in possession of the order of dismissal on count one, which is 24-01499. That's the assault GBH. So, Mr. Garris, that means that the case is dismissed without prejudice. They could reissue if they choose to. Realistically, they won't. That's a kind of a default. We are going to set the remaining misdemeanor counts 2 and 3 for pretrial. Okay, sir? All right. So we will set. So the nollie on count one is signed. Counts 2 and 3 are set for misdemeanor pretrial on
July 15th.
July 15th at 1:30. At 9:30. So we've set counts 2 and 3 for initial pretrial on July 15th at 9:30. Anything else for the record in docket 24? Oh, Ms. Wilson, you wanted to make a record on some ancillary issues.
I did, Your Honor. Thank you. As the court may or may not be aware, there were multiple emails sent the other night from the defendant's mother to myself about half my office and the court. And I just want to make it very clear that that email in no way impacted our office's decision to dismiss count 1. That was made a long time ago without her input. Further, I just want to make it very clear for everyone, it's incredibly inappropriate to be attempting to have ex parte communications with the court. Not only that, but the content of the email was incredibly inappropriate as well. There were facts of the case, character opinions of the victim in this matter, and if there are any further attempted ex parte communications with the court, I want to put everybody on notice. I will be asking for contempt. Thank you.
Thank you. So with that understanding, I just found out this morning that some emails were sent. I didn't read them. I didn't look at them. They went to, I think, the court staff and court administrator staff. But that understanding, that's been placed on the record. No more communications with the court. Any communications, unfortunately, are with yourself. So anything else for the record in 24-01499, Ms. Wilson?
I believe Mr. Feigelson has a bond request to which I will reserve my response.
All right, Mr. Feigelson.
Yes, Your Honor. Mr. Goris does have a GPS tether on, Your Honor. His issue is he does work in the medical field, and I understand when he's in the hospital, they're having issues with him having his tether on. I'd ask that the tether be removed. My understanding is that Miss Autumn is now moved out of their shared apartment. Not sure of her whereabouts. I don't even believe that my client knows where she's going to be going to. More importantly, he has no desire to have any communications with her. I do think there are minor children involved. I think there's arrangements for them through other parties to have contact to get the children exchanged for visits. I don't believe he wants to have any contact with her. I don't believe she desires to have contact with him. I don't know if a GPS tether is necessary, but I also am concerned with getting this young man employed and continuing employment. And if he can't work because of the tether, we're not doing this young man any service, Your Honor. So I'd ask for the tether to be removed today.
Ms. Wilson.
Thank you, Your Honor. It is true Ms. Owen is out of the home. So at the very least, I think a modification as to the exclusion zone is appropriate. And just for Mr. Feigelson and I's protection here, there was an exchange of keys between Ms. Owen through myself and Mr. Feigelson to the defendant because I guess he has a property interest in the area that he left. So the people have no objection to a modification of the exclusion zone. I'm not willing to divulge Ms. Owen's current location. So I think it's appropriate to remain on GPS for tracking purposes. Given the nature of the charges and the clear ongoing hostilities between the victim and the defendant's family, I'm just not comfortable with this. I don't think it's appropriate, and I think that there needs to be some kind of tracking to ensure everybody's safety, not just Ms. Otten's, but everybody.
So the any bond modification would be as to the 900 Long Boulevard address?
That's correct.
Okay.
Yep.
That would be zone notification. All right. I'm willing to modify the bond to limit the bond modification, and it would be zone notification for 900 Long Boulevard, which is the incident address, apartment 714. I'm not willing to take off the GPS or no contact or GPS, and then we can revisit this issue at the pretrial if Ms. Outen or the complaining victim wants you to represent what she has, what's an indication from the victim in the case, or she wants to show up herself and talk. But at this time, we're going to have zone notification as the 900 Long Boulevard Avenue. The GPS will continue for monitoring purposes. Anything else for the record in 24-01499, Ms. Wilson?
Just to be clear, we're removing the zone notification. Right. Yes.
I just put modified bond zone notification for 900 Long Boulevard, which is the place of the incident.
Is there going to be another zone notification? Or because the other concern is since we don't know her whereabouts, what if there's
That's the only bond, that's the only zone notification I'm aware of.
I believe the rest, I believe if we're removing the zone notifications just for tracking purposes at this point.
Right, so that, it would just be location notification
Yes,
then.
yep.
So location notification. So that's good, we can clarify this. And then GPS for tracking purposes only. All right. And then I'll hear more testimony or more indication of as to victim notification or victim as to whereabouts on that July 15th date. Anything else for 2401-499, Ms. Wilson?
Not for people, thank you.
Mr. Feigelson.
No, on behalf of Mr. Juarez, Your Honor.
All right, Mr. Garris, we'll see you on July 15th at 9:30.
Have a nice day, Judge.
You too, Mr. Feigelson. We have a Timmy Fields.
I believe that's Miss Wanji's client.
Ms. Wanji, are you ready on Mr. Fields?
May I breakout room with him for a few minutes before we get record? Thanks.
So let me put you in a breakout room. All right, Miss Wanji, I'm going to place you in room 1. You should get a prompt to go to room 1. And Mr. Fields, you'll also get a prompt to go to room 1. To meet with your lawyer.
Oh, okay.
Ms. Wanji, are you ready to go on Mr. Fields?
I am, Your Honor.
All right. So we're on the record in docket 24000611 and 24018884. That is People of the State of Michigan versus Timothy Fields. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Wanji.
Good morning, Your Honor. Melanie Biwanchi for Mr. Field, who is appearing by Zoom.
Sir, you are Timmy L. Fields, is that correct?
Yes, sir. It's not Timothy, it's Timmy.
It's Timmy, thank you. And you can hear me all right, Mr. Fields?
Yes, sir.
Thank you. This is the time set for a probable cause conference. Ms. Wilson, how are we proceeding, or would you like to defer?
I would defer, Your Honor.
Ms. Wanji, how are we proceeding today?
Your Honor, we're just going to leave it on for next week, so that I have the opportunity to review the discovery with Mr. Fields.
All right. So we're going to leave both files on for preliminary examination for next week. And that means we'll leave them on for July 11th at 8:30. July 11th at 8:30.
July 11th at 8:30. Okay.
So, Mr. Fields, you are left on for next Thursday at 8:30 in front of myself. We've had the PCC conference. Anything else for the record in 24000611 or 24018884? Ms. Wilson.
Not for people. Thank you.
Ms. Wanji.
Nothing for the defense, Your Honor. Thank you.
All right, Mr. Fields, we'll see you next week. Thank you for your appearance today.
I have a question.
Sure, but don't say anything about the facts.
No, I was just asking, on the 11th, would I have to come to the courtroom, or is it going to be another Zoom call?
Yeah, you'll have to, that'll be live in person on the 6th floor of City Hall.
Okay, thank you.
That's a good question. Thank you for your appearance today.
No problem.
Do you have officers for?
So no. I'm okay to leave?
I wasn't going to be.
Yes, you are. Thank you for your appearance.
Okay.
Okay.
And that's it.
All right, so we're on the record in docket 24-01792. That is people of the state of Michigan versus Kevin Murphy. Will the parties please introduce themselves for the record? Mr. Pfeiffer.
Yes, good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Mr. Silverthorne.
Good morning, Your Honor. Dwayne Silverthorne from the Office of Public Defender on behalf of Kevin Leandra Murphy, who is sitting next to me to my right at council table.
And sir, you are Kevin Murphy, is that correct?
Yes, sir.
Thank you. This is time set for a preliminary examination today. Mr. Pfeiffer, how are we proceeding?
Your Honor, the people are going to be requesting an adjournment at this time. On Wednesday, when I was preparing for this case, I discovered that the defendant has been calling the victim incessantly. As of that point, he had called her 399 times. In the last 2 days, he's called her another 22 times, and then this morning, he's called her 6 times. 4 of which were from lockup downstairs as recently as 8:59 a.m. And then he leaves a message for her saying, I'm going to call you when I'm done with court. Now, I did not call officers here today because I was not going to be able to proceed on 27C because this was about a 5 or 6 day late report. And I try not to do it for late reports. However, forfeiture by wrongdoing is a whole other ballgame. And frankly, Your Honor, any time to review the 427 calls now to determine if there is forfeiture by wrongdoing there, because the defendant decided to make new evidence.
And some of those, charges might end up in additional counts.
They might, Your Honor.
Yeah. Mr. Silverthorne, response.
We're going to oppose the adjournment. They don't have their officer today. They don't have the victim today. However, as an officer of court, I would let you know that in an earlier case that's currently before Judge Kennedy in circuit court, his bond has been revoked. So I cannot make the argument that if the court dismisses without prejudice today, that he would go for it.
Right.
He would. So I didn't want the court to think that.
All right, so we'll grant the adjournment request for good cause at this time. This is a good cause adjournment, so we would not expect Mr. Murphy to waive any of his rights in this matter. The allegation right now is there has been continued contact with the victim in this case. So until we figure that out, until we figure out the nature of those phone calls, let's suspend any notification. So we'll suspend, and I will indicate this is an assault. This is an assault GBH 2 counts and a DV count. So let's suspend
The calls, e-messages, and video evidence.
Yeah, suspend any calls, ability to call or contact other than the defense lawyer.
Yes.
Those are suspend any privileges except in regards to for contact, except as to defense counsel. Until we get this sorted out as to the nature of those charges and the calls and whether there's going to be additional counts in this matter. And then we'll reset the preliminary examination.
Yes, sir.
So let's set it for, I'd say a couple weeks.
Yep.
Yeah, at least a couple weeks. So 2 weeks. Let's go 2.
July 19 at 1:30.
Okay, so we'll set for July 19th, 1:30. Indicate for the record that Mr. Murphy still is incarcerated. This is a good cause adjournment to do additional investigation, and then of course to provide Mr. Silverthorne with any additional investigation.
Of course. And for the record, for July 19th, we're starting a circuit court trial that day, so it will probably be a different prosecutor handling the.
All right, we'll wait to hear from the prosecutor's office. So and but yeah, we'll set it for July 19th at 1:30 and then wait to hear if that's a different prosecutor. And then any of the additional evidence will be provided to counsel Anything else for the record in 2401-792, Mr. Pfeiffer?
Not from the people, Your Honor.
Mr. Silverthorne?
Not from the defendant, Your Honor. Thank you.
All right, Mr. Murphy, you're all set. We'll see you on July 19th at 1:30.
Oh, could a call be made to lock up downstairs so he's not able to just immediately go call her?
Yeah, we can, and when we take it down, we'll say that all his contact privileges have been suspended except for his defense counsel.
Okay, do you want me to grab anyone else while I'm down there?
Yes, I do.
You gotta get straight.
They don't have them?
What?
So
he's in custody, but he's not here?
Yes.
Hey, we're probably gonna need a new date on Jackson.
You want me to see if he can be brought?
we could bring him this afternoon. Mr. Sarks is here on Mr. Walls this afternoon.
That's true, Your Honor. I am here at 1:30, so.
I don't know, man. Stover is.
Yeah, that's the
Ow.
thing. My officer has been awake since 2 p.m. because she worked night shift. I genuinely don't know what kind of usable testimony we will
Right,
get out of that man
I completely.
this afternoon.
Just double check to make sure there's no misunderstanding between me and
Yeah,
the jail staff.
okay, yeah, so that is, so we're waiting to see the status of Jackson.
Yeah,
And then,
that's the problem I have with him going this afternoon.
All right.
Legitimately.
and then,
24 hours.
Yeah.
and then did we bring up Mr. Evans or not?
Can we do Holly?
that now.
Okay,
Can we do Holly?
you want to do Holly?
Yes, we have like witness testimony for that, for those one of the files.
All right, so let's bring up, you want to bring up Holly? Let's bring up Holly on the way up then.
Okay.
All right.
Back, they're already at it, they're back here, as long as they-
You can check on Mr. Jackson's status.
Yeah.
Mr. Washington, Mr. Johnson. May or may not be doing
I
this.
have Boyson. I have also. What's his name? Oh, that's Evans. Ooh, I've got Tina,
Well, we can do one of those.
Steljas. Yes, I don't know, and then we've got,
This,
we've got a speedway witness.
should we do,
on
Mr. Felipe Gonzalez?
Sure, might as well.
Might as well just do, so Miss Wilson, let's do Mr. Felipe Gonzalez.
Oh, okay. Oh, I forgot we haven't
Because-
done those yet.
Because I don't see Mr. Johnson.
I don't think he's.
He should come back because his client wants to. Well, it doesn't matter.
Yeah.
It doesn't. All right, it doesn't. All right, so we're on the record in docket 2401-804. That's people of the state of Michigan versus Felipe Gonzalez. Will the parties please introduce themselves for the record? Ms. Wilson.
Bill Wilson for the people.
Mr. Paul.
Thank you, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Felipe Gonzalez, who is not present this morning.
All right, this is the time set for a preliminary examination. It was initially scheduled at 8:30. It is now 9:52. It would appear that I do not see a Mr. Gonzalez in the Zoom courtroom, in the physical courtroom. Based on representations of counsel, it would appear that Mr. Gonzalez has failed to appear for the preliminary examination. We did have a translator here, two translators here, because he's a co-defendant. We let him go after about an hour. I thought that was fair. And then this is the first instance opportunity we've had to place it on the record. Ms. Wilson, how are we proceeding today?
Thank you, Your Honor. I believe that we're gonna be requesting a bench warrant.
Any comment on that, Mr. Palmer?
Your Honor, I really don't have much of a comment. Obviously, there's a language barrier here, but also at the same time, I recognize that my client did not appear for probable cause conference last week, nor did he appear today. I also recognize it's an assaultive offense, or the allegation is an assaultive allegation. So I am concerned about where he is and my ability to contact him, but I don't have any real argument against a bench warrant.
Right, I have the same concerns, but he was not here for the probable cause conference. His co-defendant's not here. We've lost track of Mr. Gonzalez wherever he is. So I'll issue a bench warrant and bond forfeiture for his non-appearance for preliminary examination. Anything else for the record in 2401-804, Ms. Wilson?
Not for the people, thank you.
Mr. Palmer?
No, thank you.
All right, thank you.
I might.
For Mr. Jackson, they confirmed he's not here. Can I let Officer Stover go home and go to sleep?
Megan is checking on you.
Yeah, let's check his status, but if everything appears to be, that appears to be an adjournment, and Mr. Sartz is obviously going to object to the adjournment.
Yeah.
So we'll place that on the record. But I have no doubt, I have no reason to doubt Mr. Sartz cannot see his client because the client wasn't brought over. So
Yeah.
that wouldn't be the first time that's happened.
And Jackson's such a accommodating.
Yes.
Yeah.
Just double check.
And that's understood. I just want to make sure Officer Stover doesn't pass out and go into a tree at his yard.
Once we put it on the record, she can go home and sleep until her shift starts tonight.
Thank you.
You know, that's a slippery slope.
Yes, yes, yes. Because then you're.
Right.
Right, yeah, all right.
I don't know of any way to do it without putting
without-
him in danger.
Yeah.
Yeah, it's a good question.
Yeah.
I thought crossed my mind.
Yeah.
I'm sorry.
Yeah, I don't know on Mr. Well, let's leave that till the end and then.
Yeah,
you know,
see if Mr. Johnson pops back in.
If he doesn't, we'll
Yep.
fail to appear as client. So listen, did you have some 4th of July break?
No, I worked.
Did you?
Yeah.
Mr. Pfeiffer, did you get a 4th of July? Mr. Austin, Mr. Palmer?
No.
No?
Not really.
I got a capital case on Monday.
I went to the fireworks last night with my kid.
I watched some of the fireworks last night and then about as much as my dog could stand. And then my dog wanted to go inside the house because it was making her crazy.
Yep.
So
That's fair.
they're beautiful, and I like them, but they hurt the dog's ears.
Yes. Yes.
So we're on the record in docket 24-00306. That is People of the State of Michigan versus Charles Jackson. Will the parties please introduce themselves for the record? Mr. Pfeiffer.
Yes, good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Mr. Sarks.
Good morning, Your Honor. Jacob Sarks, Fourth Assistant Public Defender here on behalf of Mr. Charles Jackson.
Okay, this is my understanding of what has proceeded, and then I'll allow the parties to make a record. Mr. Jackson was scheduled for preliminary examination today. This is the first preliminary examination. He was, I don't have him on as being brought over. He's not on in custody list, but but somehow he is in custody, and he was not brought over for the 9 a.m. preliminary examination. So at this time, we don't have the defendant, not to his fault at all. And then we have one witness, or at least one witness, who is working a night shift. So Mr. Pfeiffer, how are we proceeding today? And you can make a record.
Absolutely. I was prepared to proceed today. Victim was under MCL 768.27C, solely with the testimony of Officer Tyler Stover. Not only took the statements, but also eventually arrested the defendant. He can make every element, and that was my intention to find over with him. He is working the night shift. He has been awake since 2 p.m. yesterday, is what he told me. And while it could be possible to bring Mr. Jackson over this afternoon, I don't believe that it is appropriate to do so because of the effect it would have on my witness.
That's a maybe. That's
again,
that's a maybe.
It's not even a guarantee, it's a possibility. So because of that, I believe an adjournment is necessary.
All right.
It's not anyone's fault, but a clerical mistake in him not being brought over. But I believe an adjournment is necessary.
All right. Thank you. Mr. Sarks, in response.
Thank you, Your Honor.
You've not had the opportunity to speak to Mr. Jackson because he was not brought over.
This morning.
Yes, this morning.
This morning. Thank you, Your Honor. Mr. Jackson was very insistent that he wanted his preliminary examination this morning. It certainly was not his fault that he was not brought over. Respectfully, Your Honor, it's my understanding the complaining witness did not appear. She is a critical witness for the prosecutor's case. That would suggest to me that, certainly there's potential issues with the prosecutor moving forward, albeit he has announced he wants to try to proceed without her participation. But still, Your Honor, it's a serious red flag about the strengths of this potential case for the prosecutor. I would move to dismiss at this time, Your Honor, due to the failure for the complaining witness to appear here. But in the alternative, if Your Honor is convinced that a good cause adjournment is warranted, I would request a reduction in Mr. Jackson's current bond amount, which is quite sizable cash surety bond, which due to his indigent status, Your Honor, he's unable to currently afford. He does have family here today. His mother, friends are here in support of him. I don't believe the witnesses, so he does have plenty of family support in the community. It wouldn't be a flight risk.
All right. Thank you. So we'll visit bond in this matter. I will grant the good cause adjournment based on the representation of the council. And Mr. Jackson was not brought over this today. And we will grant the good cause adjournment so Mr. Jackson doesn't waive any rights. We will reset the preliminary examination. And I know Mr. Pfeiffer and Mr. Sarks, you have trial schedules that we're going to work around, but we'll give you a date and then you can look at it. And then if you get coverage, we'll work along those lines. But a reset for the preliminary examination. That's probably too soon for subpoenas.
I didn't know since the officer was here. That would work.
It usually takes
at least 10 days. Yeah, at least 10 days.
Not to get subpoenaed them, but to make sure that they are able to physically make it.
July 18th at night.
July 18th at 9 o'clock.
Perfect.
Mr. Sarks, does that work with your calendar?
It should work, Your Honor.
All right.
Thank you.
So we'll set it for July 18th at 9 o'clock. Mr. Pfeiffer, you heard the argument for bond reduction in the matter. Any comment on the argument for bond reduction?
This is a violent crime involving him trying to stop her from contacting police, involving a firearm with a person who has a history of felonious assault, and also has a history of being he literally, one of his convictions is absconding from bond. He's an habitual fourth offender. Life offenses are at play here. I believe bond is appropriately set.
2 gun charges. It's the 4th offense notice. I understand the nature of the motion for bond. Also, it's not his fault that he's not here today because he was not brought over by some technical glitch. But I'm going to leave bond at the same because of the habitual offender notice. This was set by the magistrate. It's a pretty high bond to be set by the magistrate.
Yep.
So, all right. So I'll leave bond as is. Bond remains without modification, and we will reconvene on July 18th at 9 o'clock.
Thank you, Your Honor.
Anything else for the record in 24-00306, Mr. Pfeiffer?
Not on behalf of the people, Your Honor.
Mr. Sarks?
No, Your Honor. Thank you.
All right, thank you. You can go, or did Ms. Wilson go to let?
I released Officer Stover.
Okay. And this is on 1793.
Is there any joy in those eyes? Or they
No, they were done.
All right, so we're on the record in docket 24-01793. That is People of the State of Michigan versus Terrence Hawley. Will the parties please introduce themselves for the record? Mr. Pfeiffer.
Yes, good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
And Mr. Austin.
Thank you, Your Honor, and good morning. Jared Austin appearing today on behalf of Mr. Hawley. He is present to my right, adjacent from council table.
Okay, and so you can come over, Mr. Hawley, you can come over here, sit next to your counsel. And sir, you are Terrence Javante Maurice Hawley, is that correct?
Yes, sir.
All right, thank you. This is the time set for a preliminary examination today. Are there any pretrial matters, or Mr. Pfeiffer, how are we proceeding?
Your Honor, the people are prepared to proceed today. We were prepared in both of Mr. Hawley's files that are currently before this court.
Right.
Do you want to make a record? There has not been an offer that has been made, and that's because of the number of files. The intention is to provide a global offer once it is up at the circuit court.
All right, and that's your understanding, Mr. Austin?
It is, Your Honor. No offer has been conveyed at this time.
All right. Are there any preliminary matters to come to the court's attention before we get started on 24-01793? I will invoke sequestration, which will allow that one party not to watch another witness's testimony. But I'll leave it at the hands of counsel to let me, you know, your case better than I do. So let me know if anybody, if that sequestration order should be invoked. Anything else, Mr. Pfeiffer?
No, Your Honor.
Mr. Austin?
No, Your Honor, I was just going to ask for sequestration, which the court has already granted.
So, perfect. All right. Mr. Pfeiffer, you may call your first witness.
Thank you. People call Anna Alanis. Yeah, you can accept that. Heart rarely steals.
All right, Miss Alanis, you can come and stand right in front of myself. And I want you to spell your first name and last name for the record.
First name A-N-N-A, last name A-L-A-N-I-Z.
A-L-A-N-I-Z. How do you pronounce that?
Eleni.
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 There you go.
All right. Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yeah.
All right. Have a seat. The microphone, if you could talk to that, is for recording purposes, but it doesn't amplify your voice.
Okay.
So please project as best you can. Mr. Pfeiffer, when you're ready, you may proceed.
Thank you. I am going to need the HDMI cable at some point. I have a couple of digital photo exhibits. Thank you.
Okay.
Good morning.
Morning.
Anna, where do you currently work?
I am the general manager at the Speedway located on Penn and Miller.
Now, Penn and Miller, is that in Lansing?
Yes.
In Ingham County?
Yes.
That's appreciated. How long have you worked there?
Ooh, I've worked there at that location for, I think, about 2 years.
So were you working there on October 24th, 2023?
Not that I can remember, but if it's Monday through Friday, chances are very good because I work Monday through Friday.
The court could take judicial notice that October 24th, 2023 was a Tuesday.
All right. Court can take judicial notice of last year's calendar that was a Tuesday.
Thank you, Your Honor. Now, how frequently do you interact with the police when you are working at that speedway?
Probably on a weekly basis. It's not in the very best part of town. So.
Do you remember speaking with officers when you were working there on October 24th, 2023, sometime in the fall last year about assault?
Not that I remember.
Would looking at a copy of the police report help refresh your memory about this incident?
Correct.
I can approach you.
You may.
Now, Anna, I don't want you to read aloud from this. What I'd like is for you to read it to yourself until it's sufficiently refreshed your memory about this incident, or you just think it's not going to be possible to do so.
Okay.
You let me know. I'll come take it back from you. Ask you the question again.
Oh, yeah.
Is that sufficiently refreshed your memory?
Yeah, I remember.
Your Honor, if I could come retrieve the document.
You may.
Thank you. And for the record, I did show this to Mr. Austin before I handed it to the witness.
All right, thank you.
So that helped refresh your memory?
Yeah, I remember that specifically. Yes, correct.
So you remember talking to officers last October about this incident that you saw?
Yes.
What can you tell us you witnessed about this?
So I came into work and then all I saw is a young lady and a guy come in. And then she goes to the sink area and she's just bleeding. And I had to go because I'm like, you're bleeding all over the store. And the first thing I remember saying, he's like, I didn't do it. I didn't do it. I found her like that. I found her like that. And I went over there and I'm like, are you okay? What's going on? She wouldn't really talk to me. She was scared. I said, and then he was by her. He would never leave her.
So you never had an opportunity to even talk to her without him, right?
No, he wouldn't. He would stay close by her. And then, so we're like trying to help her, but she's just bleeding everywhere. It's just
Where is she bleeding from? I know that you're gesturing with your hands by your mouth.
In her mouth is bleeding, and she's just trying to put water in her mouth and spit it out, but it's just
keeps coming.
It just keeps coming. And at a certain point, we do self food. So I was like, hey, you know, I'll call 911 for you. Let me sit you outside. You can wait on them because she's just pouring blood everywhere.
You say you self-lose, it's a health hazard.
Yes, yes. Because she's, like I said, and then it made me nervous too, because usually a person doesn't say, I found her like that, and it's just following her around the store wherever she's going, he's going. So we sit her right there. We're on the phone with 911. And then they're on their way and he doesn't, like, he's sitting right next to her, like he won't leave her. So we can't really ask her any questions.
At some point, do they leave your store?
Yeah, we sit her outside and then, so I go back to waiting on the customers, the cops come, we tell them what's going on, and I'm not sure, I can't remember what happened after that.
Okay. Do you remember showing them some surveillance photos?
Yes.
Your Honor, I'd like to approach the witness what's been marked as People's Post Exhibit 1.
You may.
Do you recognize what's on the screen?
Yes.
And how do you recognize this?
Because that was the woman that was bleeding profusely, and then he was with her the whole time.
So does this appear to accurately show some of the surveillance that you showed to the officers
Yes.
that day? And that shows what you saw?
Yes.
Your Honor, I'd seek to admit People's Post Exhibit 1 into evidence.
And counsel, you've had the opportunity to review and see People's Exhibit 1.
I have, Your Honor.
Any objection to the admission of People's Exhibit 1
Without
for purposes of prelim?
Without objection.
Without objection, People's Exhibit 1 is admitted into evidence for purposes of prelim.
And I seek to publish to the court at this time.
Absolutely.
Now, the man that you saw who kept saying he didn't do it who's in that video. Do you see him here in court today?
Right there.
Record reflect that she just pointed to the defendant and has identified the defendant.
Has any objection to the witness identifying the defendant for purposes of prelim, Mr. Austin?
Without objection.
Without objection, the witness has identified the defendant. You may proceed, Mr. Viper.
Your Honor, I do not believe I have any further questions for this witness.
All right, thank you. Cross-examination, Mr. Austin.
Yes, Your Honor, thank you. Morning.
Hi.
So what time of the day or night are we talking about when this
You're
occurred?
talking early mornings. I had just gotten to work. I'm talking like probably between 5 and 7, somewhere between there.
AM? Okay. What was your normal shift that you would have been working at that time?
I get in at 5 in the morning.
And was there anyone else there working but you?
There was a couple of us. Usually it's me, the cafe manager, as well as my overnighter, and probably one other person. There's usually about 2 or 3 of us that early in the morning.
And essentially this morning, the incident you're describing, you were working behind the cash register, is that right?
Yeah, so in the morning I go in, I do my morning things right there. And so when I'm at the so there's the door, there's a little block of product, and then there's my register. So when she comes in, she goes straight to the sink. She goes right around, and I literally stop, look up, he's right there. He's like, I don't know what happened. I found her like this kind of thing. And I'm like, that's weird.
What is this sink that you're talking about? Where is
It's
that
like a
located?
hand washing sink. People come in and just wash their hands right there. It's located on our coffee island.
Okay. And the other workers that would have been working at this time, where were they when you saw these 2 individuals?
Oh, I don't remember for certain. Probably one was in cafe area, which is right like when you walk in towards the back. And then probably one on register with me, probably one behind the register with me.
And were there any other customers in the store at that time that you can recall? Or do you recall?
Probably. We are usually busy around then, but not like super busy. Maybe 1 or 2 people, maybe.
And you're just basing that on how many customers would normally be there at that time?
Yeah.
It's fair to say that you don't have any independent recollection of this incident, if there were any customers, or if so, how many?
Not really, no.
Okay. And this gentleman that you described that you said that essentially went everywhere where the lady that was bleeding went. He didn't grab a hold of her. He didn't have a hold of her arm or anything like that.
So when
correct?
she was at the sink washing out her mouth and we went over there to, do our thing, like, are you okay? What's going on? After he said what he said, because, it's not the first time this has happened. So we kind of know what to do, kind of like try to get her by herself to talk. He walked away for a little bit, and then she was too busy putting water in her mouth because it just kept coming. But as soon as I walked away, he walked right back up to her and was whispering in her ear.
But in other words, he walked away, he didn't have a hold of her, correct?
No, but he was never more than 5 feet away from her at any time.
And they both left the store, correct?
I sat her down because I told her the ambulance is coming, like we called 911. She knew we had called 911, and he sat right next to her. As soon as I had other people
In the
inside,
store or out of the store?
outside of the store, right in front of the doors.
And did you watch them as they sat down, or once you escorted them outside and they sat down, did you stop watching them at that point?
I watched them for like a couple seconds after that. Like I said, we get kind of busy, so I didn't see after that, no.
And you have no way of knowing how long they were there after they went outside and sat down, correct?
Not to my recollection.
Okay. And you have no way of knowing, because you didn't witness it, whether they left separately or together, is that correct?
Not that I remember.
All right, thank you.
Any redirect? Mr. Pfeiffer.
No, Your Honor.
May this witness be excused?
She may.
Mr. Austin.
Yes, Your Honor.
Thank you for your appearance today. You're excused. Further witness, Mr. Pfeiffer.
Your Honor, the people call Officer Stacy Myers. Hey, Clark, you grab Officer Myers from and for the time being, I'll select the laptop to take Exhibit 1 off.
Yes, you may take, you can no longer needed to publish that.
I'll probably be using it at some point when I talk to Officer Myers, but I don't need to have that up there
All right.
before she starts.
Hey, Officer Stacy Myers?
Yes.
Okay, you can come up here. Stand right in front of me and spell your first name and your last name for the record.
Stacy, Stacey, last name Myers, Meyers.
Please raise your right hand. Do you solemnly swear affirm, tell the truth, the whole truth, and nothing but the truth, under penalty of perjury?
I do.
All right, have a seat. The microphone is for recording purposes for the court office, for court recorder. So please project as best you can. And Mr. Pfeiffer, you may proceed.
Thank you, Your Honor. Morning, Ms. Myers.
Good morning.
Where are you currently employed?
Lansing Police Department.
And what is your role there?
Right now I'm in the Special Operations Division.
Now, were you still working for the Lansing Police Department back on October 24th, 2023?
Yes, I was.
And were you patrol officer at that point?
Yes, I worked the morning shift, 6 to 4.
Now, on that day, did you respond out to initially a speedway at 6041 South Pennsylvania Avenue?
Yes.
Is that in Lansing?
Yes.
Is that in Ingham County?
Yes.
And why did you go out there?
We got a complaint of a female that was calling for help, that she was assaulted.
Now, did you locate her at that speedway?
No, I did not.
It was at a nearby location,
Yes.
correct? And once you located her, how did she appear?
She was laying on the ground, crouched up in a ball. She was very incoherent, very hard to communicate with. She looked like she was assaulted.
What do you mean she looked like she had been assaulted?
She had blood on her face, around her lips. She had some bruising and some swelling around her face.
And did you see any male with her there?
At that point, no.
No, she was by herself.
Yes.
Did she end up going to the hospital?
She did.
Did you talk with her more there?
I did.
And as a result of talking with her, you determined an assault had taken place?
Yes,
Did you determine that that was domestic in nature?
I did.
Did you determine that it was recent?
Yes.
Your Honor, I'm going to object to lack of foundation. I think we need more foundations before we could just reach those conclusions.
I think this is the foundation for the statute. So understanding the objection, it's overruled. No content has been indicated except for the nature of the foundation for the 768.27C. So Mr. Pfeiffer, you can proceed with the question.
Thank you. And did the injuries you observed seem to match with what she told you happened?
Yes.
Your Honor, at this time, people seek to proceed under MCL 768.27C.
Okay, any objection, Mr. Austin, under pursuant to the domestic violence statute on hearsay statements made to the officer?
Oh, I have a standing objection, Your
All
Honor.
right, thank you. With the understanding, the standing objection, there is a 768.27C statute which would allow hearsay to come in at the preliminary examination for purposes of preliminary examination. And I will allow questioning concerning this matter pursuant to that statute. So Mr. Pfeiffer, you may proceed. I believe the foundation has been met. The statement purports to narrate, describe, or explain the infliction or threat of physical injury, action in which the evidence is offered is involving a domestic assault, which was both of those were testified to. Statement was made near the time of the infliction or threats of physical injury, and the statement was made to a law enforcement officer. As Officer Myers indicated, she was on the road working. I believe that these carry the issues of trustworthiness in regards to whether the statement was made in contemplation or pending and anticipated litigation, which would come out later, and whether there was bias or motive to fabricate the statement. And the statement's been corroborated essentially, but those will be weighed in regards to trustworthiness concerning the statement. You may proceed, Mr. Pfeiffer.
Thank you. Now, did you identify the one we were speaking to as Jessica Redmond?
Yes.
What did Jessica tell you had happened?
She had said that she was assaulted by Mr. Holly.
And did she give you a first name for Mr. Holly?
Yes.
And what was that name?
Terrence.
And did she say how she knew Terrence?
They were in a dating relationship.
What did she tell you happened in that assault?
That she was punched, kicked, and stopped.
Did she say how it started?
I would have to review my report.
This was nearly a year ago. We'll get a copy of your report to refresh your memory.
That would be nice.
Altering it. It's just got the circle from the last one. Officer Myers, go ahead, review this to yourself silently. We feel it's sufficiently refreshed your memory about the question of how this started, or you feel it's just not going to be possible to do so. Let me know. I'll come take it back from you, ask you the question again. All set? If I could retrieve it, Your Honor?
You may.
Because I keep forgetting to do this ahead of time. For record reflect, I showed it to Mr. Austin before I gave it to the witness.
The record may so reflect.
That help refresh your memory?
Yes.
Now, how did Ms. Redmond tell you this started?
She was with a friend. I believe the last name was Malcolm. I couldn't remember exactly what the name was, but they were walking through a cut through, and Terrence had located them and started assaulting her and dragged her to a van behind the hotel and assaulted her.
He assaulted her in the van?
Yes.
And was that cut through by the speedway?
Yes.
Did she tell you if he threatened her at all?
Yes, she did.
And what did she tell you about that?
She said that he threatened to kill her and threatened to harm her if she told anybody.
And then did she give a description of Mr. Holly?
Black male with dreadlocks.
Now, some point after speaking with Ms. Redmond, did you go back and look at surveillance footage at the speedway?
I did.
Your Honor, I could show the witness People's Exhibit 1.
You may.
Thank you. Now, this is People's Exhibit 1. Does this appear to be a still from that surveillance footage that you saw?
Yes.
Now, is the woman in there the one you identified and spoke with as Jessica Redmond?
Yes.
And the male in that, did that seem to match the description that she gave you of Terrence Holly?
Yes.
Do you remember if she told you what he was wearing?
Not exactly.
Would look at a copy of your report refreshed out. I may approach, Your Honor.
You may. Let the record reflect you've shown counsel the report.
I was getting ahead of it this time. that help refresh your memory?
Yes.
So what did Jessica tell you Mr. Holly was wearing?
Black pants, blue coat.
And does the male in that photo seem to be wearing a blue coat?
Yes.
Now, Your Honor, I'd like to show the witness lesson marked as People's Posted at 2.
So motion to admit or request to admit People's Proposed Exhibit 2, that's not been admitted enough.
No, I can show it to her.
All right.
I did. Officer, do you recognize what's in People's Proposed Exhibit 2?
Yes.
And what is that?
That's Jessica Redmond.
Does that appear to accurately show how she looked when you saw her in the hospital?
Yes.
Your Honor, I'd seek to admit People's Proposed Exhibit 2 into evidence.
Any objection to People's Proposed Exhibit 2? Motion to admit into evidence.
Without objection.
Without objection, People's Exhibit 2 is admitted into evidence. And you may proceed.
Thank you. Do you remember if Miss Redmond told you that she was in that speedway with someone?
I'd have to refer to that. Word.
Now, did you confirm that the individual that's in People's Posted Exhibit 1 was Terrence Holly?
Yes,
And do you see that man here today?
I do.
And where is he located?
He's located.
Record of reflect she has identified the defendant.
Any objection to the witness identifying the defendant for purposes of prelim, Mr. Austin?
I just have some brief voir dire on that, Your Honor.
You may.
You stated that, good morning, officer.
Good morning.
You stated that you made a determination that the person you saw in that video was in fact Terrence Holly. Did I understand that correctly?
Yes.
How did you determine that, or what did you do to make that determination?
We always, when we find out who they are, we run them through our SRMS or our lien verification.
And that was based upon the information that Ms. Redmond had given you?
Yes.
And she gave you a first and last name, correct?
Yes.
Did she give you a middle name?
I don't recall.
Did she give you a date of birth or approximate age?
I don't remember the date, the age that she gave me.
But did she give you an age, or did you remember her giving you a specific birth date or date of birth?
I don't.
Thank you, Your Honor. That's all the questions I had.
Thank you. Continued questioning concerning redirect, Mr. Pfeiffer.
And just for the record, Your Honor, I would just object for purposes of proof.
Thank you.
Was the information that she gave you enough to narrow down an individual in the SRMS database? And that individual has a photograph in the SRMS, correct?
Yes.
And that matched not only the individual seen in the surveillance, but also the individual here in court today.
Yes.
Thank you. I renew my request for director to reflect that she's identified the defendant.
All right. And it's subject to the objection of identifying the defendant through lien, but based on the photograph that was indicated, with the understanding that the objection has been noted, the objection at this time is overruled, and the witness has identified the defendant for purposes of preliminary examination.
Thank you. Your Honor, at this time, people have no further questions.
Cross-examination, Mr. Austin.
Sure. Thank you. Good morning again, officer.
Good morning.
So was the first place you were dispatched to, was that the Speedway location?
Yes.
And what did you do there? Who did you speak? Did you speak to anybody there?
We spoke to the person inside, and which I don't know if she's an employee or manager. There's usually people working inside the Speedway. We checked the area, spoke to people in there. I found out that there was a call earlier that morning to that location, and they did not locate anybody either.
And so how many people in the Speedway did you speak to? One or more?
I believe just one.
And then at some point later after that, you locate Miss Redmond, correct?
Yes.
Okay. And exactly where was that again?
It was on a Ramada Drive, which is by the hotel.
America's Best.
Yes. Right kind of to the north side of the hotel to, right before you get to the hotel, on the road, on the side of the road.
So was she outside in the parking lot, on the sidewalk, or somewhere else?
She was, laying in between the road and the sidewalk on the grass area.
And how did you end up finding her at that particular location?
Somebody had called, I don't know if they called from, like, saying they're from Speedway. There was I believe, a male subject that called, said that she needed help.
And gave the location of the
Correct.
America's Best?
Yeah, that area.
Okay. And was anyone else around Miss Redmond when you came upon her?
No.
And you stated that she had given you the name of a friend that was also with her when she said that she was assaulted by Mr. Hall. Is that correct?
Yes.
Okay. And she gave you a first and last name for that person. Is that
Yes.
correct? And did you make any attempts to find out who that person was or to locate that person?
Yes.
What did you do in regards to that?
Tried to, I'd have to refresh my name on what the name she gave, but I tried to look in our system, like SRMS or anything like that, with anybody that resent or has that name or anything like that. Didn't come up with anybody that existed by that name or phone number.
And did she give you a specific spelling for the name, or did you just assume what the spelling might be?
Assumed, because she couldn't remember.
And did you make multiple searches using different variables or different spellings of the name?
Yes.
Okay. And would you be able to approximate how many of those that you did?
Maybe 4.
And was she able to give you an approximate age of this person? Did you ask for that?
Yeah.
And did you ask her what the race of this person was?
I asked her several questions, but because of her injuries and her disorientation, she was unable to answer a lot of questions.
And did you ask her for some type of physical description of this person as to what he looked like or what he may have been wearing?
Yes.
Was she able to answer that?
No.
And regarding the description that you were talking about, you said that she gave you of Mr. Holland.
Yes.
Did she give you an approximate description in terms of his height?
No.
Did you ask that question?
I don't know if that was a specific question.
Would that be something you would normally ask someone when they're being asked to describe someone who assaulted them?
Yes.
Okay. Would it be a regular question in that situation for you to ask maybe an approximate weight or build of the particular person?
Yes.
Did you ask Ms. Redmond that in this instance?
I believe so.
Did you ask her for any distinguishing characteristics of Mr. Hawley, such as scars, tattoos, things of that nature? Was she able to answer that question?
No.
And you had indicated that she was assaulted in a van, is that correct?
Yes,
And from your speaking with Miss Redmond, it was your understanding that that was a van located somewhere behind the America's Best
Yes.
motel? Okay. And were you able to get any further description from Miss Redmond as it related to that van?
no,
Were you able to locate such a van?
no,
Did you look for a van or attempt to locate a van based upon what she had told you?
yes.
And what did you do in furtherance of that?
We drove over to the hotel. I walked around, went around all the buildings, did not see anything that matched any type of van.
Was this before or after Miss Redmond went to the hospital?
That was after.
Did you speak to anyone that was working in the motel?
I don't believe so.
And you did not locate any independent witnesses that claimed to witness or hear the assault of Miss Redmond, is that correct?
Yes, ma'am.
No,
No.
sorry.
And did you ask Miss Redmond if she had recently taken any type of medication or controlled substances?
No,
Is that a question that you would normally ask someone when they're being interviewed?
not necessarily.
So in other words, sometimes you do,
Sometimes,
and what warrants that?
depending on their demeanor, their actions, things of that nature.
And I think you would describe Miss Redmond during your encounter with her as kind of incoherent, is that correct?
Yep.
And you have no way of knowing whether she was under the influence of any type of alcohol or controlled substances at that time, is that correct?
During my, like making contact with her, she did appear to be intoxicated.
Oh. And that was an observation you made from speaking with her?
Yes.
Okay. But she wasn't given any type of a PBT or anything like that that could have pinpointed that down more precisely, is that correct?
No, you can't give a PBT to somebody that has an injured mouth.
You know what the approximate time was when you discovered Miss Redmond outside the America's Best motel?
I believe maybe around 7. I
7 a.m.?
referred to my report.
7 a.m. you're talking about?
Sounds about right.
You recall if the sun was up yet?
I think it was pretty dark at that time because it was during like the winter, the darker.
October. Thank you, Your Honor. It's all the questions I have.
Thank you. Any redirect, Mr. Pfeiffer?
When you were speaking with her, were you concerned about Whether she was intoxicated or about the injury she had sustained.
Her injuries.
Why?
She had a very hard time talking, almost like mumbling. She appeared to be fearful. She didn't want a lot of interaction with me when we first made contact.
And that's when she was still just out on like the public street.
Yeah.
But once you were actually in an enclosed hospital, she was more willing to talk to you about what happened.
She was.
Thank you. I have no further questions, Your Honor.
May this witness be excused from the people.
She may, Your Honor.
Mr. Austin, may this witness be excused from the defense.
Yes, Your Honor.
With that understanding, thank you for your appearance today, ma'am.
Thank
You're
you.
excused. Further proofs from the people, Mr. Pfeiffer.
None, Your Honor.
Did the people rest?
Yes, Your Honor.
Any proofs today, Mr. Austin?
We'll rely on the evidence presented, Your Honor.
Thank you. Motion for bind over from the people.
Yes, Your Honor. I am requesting that this court bind over on count 1, assault GBH. I think People's Exhibit 2 is a pretty good reason as to why a GBH is warranted, because that is a pretty serious injury, not including the other bruises that the officer said that she noticed. I believe there was intent to do great bodily harm here, less than murder. So I'd ask that you bind over on count 1. Count 2 is a misdemeanor that carries. And I'm going to have 2 requested added counts. My apologies, Wendy. Requested added count 3 of unlawful imprisonment. The PAC code is 750.349B as in boy. Under the legal theory of knowingly restraining Jessica Redmond to facilitate the commission of assault intent to great bodily harm, a felony. As the officer testified, Ms. Redmond told her that she was walking a speedway, and then he grabbed her, dragged her, threw her in a van, and was assaulting her. He restrained her in order to commit that felony. So I believe there is a sufficient factual basis for the added count 3 of unlawful imprisonment. And then last, the people will be requesting an added count 4 of interfering with a crime report by threatening to kill or injure. The PAC code for that is 750.483. A is in apple, 2, B is in boy. As the officer testified that the defendant threatened Ms. Redmond that if she were to tell anybody about what just happened, about him assaulting her, he would kill her. That's after he was already threatening to kill her during the assault. And, Your Honor, I believe that is a sufficient factual basis for interfering with a crime report. There is no requirement that she be actively trying to call police. There is no requirement that she say, I'm going to call the police. It is only that he was trying to stop her from calling police and telling them what happened, which pretty sure the person he didn't want her talking to wasn't just Joe Schmo down on the corner. In fact, he was threatening to kill her if she told anyone. I believe just from common sense alone, it's pretty clear he was trying to stop her from telling any type of law enforcement. He had just viciously assaulted her. And especially for a probable cause burden, I believe there's sufficient factual basis to bind over on the requested added count 4. Thank you.
Thank you. Mr. Austin, response to motion for bind over.
Yes, Your Honor, thank you. Obviously, we did not hear from Ms. Redmond or anyone who claimed to have actually witnessed the assault or whatever took place or did not take place that day. I think it's probably obvious from the testimony and from the pictures, something obviously happened to Ms. Redmond. So I certainly think on a probable cause determination, they have probably likely met any burden as it relates to a assault or probably even a GBH. The question then becomes the issue of, has there been sufficient probable cause presented that would tie Mr. Hawley to that assault? And if there is sufficient probable cause to bind over on the counts that the people have requested. And on those basis, I would be opposing the people's request for bind over on all counts, Your Honor. And I would not ask the court to bind over at this time. I'm not going to give a lengthy argument on that. Obviously from the officer's testimony that Ms. Redmond appeared to be incoherent. She appeared to be intoxicated and under the influence of alcohol, which could obviously influence or impair or impact, people's memories of events. And that may very well be a question of fact for a circuit court trier of fact, Your Honor, but as the court is aware, the court is the sole determiner of credibility at this stage. So I would ask the court to weigh that and factor that in to the court's decision today as it relates to the people's request for bind over. As to the added counts, Your Honor, particularly the unlawful imprisonment count, the theory that Mr. Hawley was unlawfully imprisoning or restraining Ms. Redmond in order to facilitate the commission of the great bodily harm crime. If in fact there was a great bodily harm crime committed by Mr. Hawley, that had already been committed. Whatever had happened, that was already done. That was already completed. That was already over with. So I think it would be improper to bind over on that as it relates to the added count of interfering with a crime report. I believe that the statements that Ms. Redmond gave to the police would be insufficient to bind over on that as well. I don't think there was any specific mention that Mr. Hawley told her not to call the police or not to report it to the police or anything like that. So for those reasons, Your Honor, I would oppose the request for bind over. Thank you.
Response.
There is testimony that he dragged her into a van and assaulted her. That is restraint under the criminal jury instructions, which reads, restraint means to forcibly restrict a person's movement or to forcibly confine the person so as to interfere with that person's liberty without their consent and without lawful authority. It's clear that he restrained her, that he restricted her movements, that he forced her, and because the words that were used were dragged, and then he assaulted her. And even if the defense's argument was correct, which I'm not saying it is, because she said that the assault happened after he dragged it before because it was continuous, that would still be a basis to bind over unlawful imprisonment under the theory of knowingly restraining her to facilitate flight after the commission of the felony. So either way, unlawful imprisonment should be bound over. And for the interfering with the crime report, he threatened to kill her if she told anybody. It's pretty clear what the intent was there. I'd ask that you bind over as requested.
Like the standard for preliminary examination is probable cause being the second lowest standard in criminal law. So that is the standard. The court believes that the people have proved the date of the offense. That would be the date of October 24th, 2023 was indicated that it was a Tuesday of that date, a Tuesday of that week by witness Anna Alanes. The venue of the date is in or about the whereabouts of Speedway. So that would be the 1600 Speedway addresses where the initial venue took place, and thereabouts because it's down the street from there. It's my understanding. And that's in the city of Lansing, Ingham County, as indicated. It was down the street at in the vicinity of the American Inn that some of the assaultive behavior took place. So the location and venue in the city of Lansing, Ingham County, I'm going to say in the vicinity of the Pennsylvania Speedway address, I think is probably incorporates the entire address. I think the actual address is the Ramada Inn Drive, America's Best Hotel, and I think the indication was that it was I have it at the 601 address. It's the apartment C address here, but that would be the address because it's not a locale, it's just a vicinity.
Correct. This was a fluid incident.
Right.
In this area.
So yeah, so I would say the Pennsylvania address is the reporting address, the American is in address, and the assault occurred there so in the vicinity of the Speedway address on Pennsylvania Avenue in the city of Lansing, Ingham County. I've had the opportunity to review people's exhibits 1 and 2. Witness 1 was Anna Alanas. Witness 2 was Stacy Myers. I believe the assault with intent to do great bodily harm, count 1, has been proven by probable cause evidence in that Anna Alanas made identification after at the Speedway. She's the manager. She indicated that Miss Redmond came in and was bleeding profusely. They attended to help her at that time. She made identification of Mr. Hollis, who also was present. Identification was made. She was placed on the outside of the Speedway. She was bleeding profusely from her mouth. From her mouth seemed to be the main point. Then Officer Stacy Myers indicated that based on 768.27C, the statements were made by Miss Redmond indicating, 1, that she was kicked, beaten, stomped by the defendant at the outside of the American Inn location, and then she indicated that she was she never indicated. She indicated the nature of the beating, which is beaten, stomped, and kicked. That she was hit. She indicated that and this communication comes as she's A, maybe intoxicated, B, she's obviously suffered a traumatic beating. That's indication from the Speedway manager and then some of the photos afterwards. So I believe probable cause has been met in count 1, that the defendant did assault Jessica Redmond with intent to do great bodily harm less than murder, which is the allegation. And kids found over on count 1. Count 2, domestic violence follows as a misdemeanor. Count 3, the unlawful imprisonment, was the statement made to Miss Meyer indicated that on that date and time at the offense location that she was dragged from the incident of the assault to the van where the assault took place, or the majority of the assault took place. This seems to be somewhat fluid, but it seems like that was she did indicate she was dragged, which would indicate that it was against her will. I believe there's probable cause evidence to bind over based on the statements made to Officer Myers from Jessica Redmond for count 3, which is the unlawful imprisonment under 750.349B. And so I'll bind over on that count with the offense location being it's at or around the Speedway address right down the street from American Inn in the city of Lansing, Ingham County. There's also testimony from Tracy Myers that indicated, Officer Tracy Myers, that Jessica Redmond did indicate that if you tell anybody, I will beat or kill you. I think it can be inferred at a probable cause level that she was indicating that she was not able to make a report of the incident at that time to anyone. Law enforcement, they ended up at the Speedway, but anyone. So this seems to be chronologically before the Speedway event, after she'd been beaten, while she was being beaten, and then they end up at the Speedway, and then Officer Meyer takes the report. I find it a probable cause level that interfering with the report of a crime has been met at the location of South Pennsylvania on the date and time as requested, based on the Tracy Myers testimony concerning Jessica Redmond. And I will bind over on 750.483A2B that this was met at a probable cause level. Identification was made not only by Miss Redmond and the officer through the investigation, but then ultimately really confirmed by the photograph and by Miss Alanis' testimony as the Speedway manager. So I believe that location, offense, venue, ID, and date have been made, and I will bind over on the 4 counts requested. The habitual, so what counts 1, 3, and 4, count 2 is a misdemeanor, and the habitual offender notice is also follows this to circuit court. So I will indicate that the bind over was held on today's date, which is July 5th, 2024. And count 3 is bound over as unlawful imprisonment. for the new, and that comes under 750.349B, and count 4, which is the interference with the crime report, is bound over also at 750.483A2B. I'll bind over on both counts. Anything else, though, it's bound over on counts 1, 3, and 4. 2 is the misdemeanor, it follows, and the habitual offender notice also follows. Anything else for the record? And before I sign the bind over in 2401793, Mr. Pfeiffer.
Yes, Your Honor. And only because I never know what the microphones end up actually picking up for the court reporter. So I'd like to make sure that there is a record that, and I didn't want to interrupt the court during its decision at the end. During the people's re-argument on the added counts 3 and 4, the defendant, unprompted, decided to start saying into open court that, insisting that he was actually the one who called 911 during this incident. And I'd like to make sure there's a record of that because he's effectively putting himself involved in this.
Your Honor, I'm going to object. Any statements by Mr. Hawley were intended to be communicated through defense counsel, so that would be highly inappropriate.
Right.
He was not addressing the court. That
There
was a statement that was intended, made for defense counsel.
He started those statements when defense counsel was still up here talking in its argument.
Right.
He
So-
was saying openly, directly out towards the court.
So the main aspect is communication is the argument made. Any communication with counsel is traditionally left out, but it is a part of the court record. I mean, if you talk loud enough for everybody to hear you, then it's part of the court record and it's written on. So I think that the court record would speak for itself regarding that. So with that understanding, the videotape is what the videotape says, and the transcript will indicate what was being heard between counsel if it was able to be heard. Anything else, Mr. Austin, on 2401793?
No, Your Honor, thank you.
All right. So this case is bound over. Anything else, Mr. Pfeiffer?
No, Your Honor.
All right. I will sign this. So your time in district court is done. You've been bound over to circuit court. You'll get your next date from Mr. Austin, your attorney in circuit court. Anything else for the record? So it's bound over as charged with additional counts 3 and count 4. And that's all for the record in 2401793. Thank you, everybody, for your appearance.
Thank you, Your Honor.
So we still have another file on Mr. Hawley, so we can probably do Mr. Johnson's.
That would be my request, Your Honor.
Yeah, Mr. Johnson's on
Jose Gonzalez.
Jose Gonzalez, since you're here. So let's go ahead and put that on the record. And then when we we'll do the second prelim, and then we can bring in Mr. Evans, who's incarcerated at this time. Mr. Palmer's out back there waiting patiently. So, all right, so we're on the record in docket 2401803. That's People of the State of Michigan versus Jose Gonzalez Cardenas. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Washington, Mr. Johnson.
Kareem, good morning, man. Please on the court. Kareem Johnson on behalf of Mr. Gonzalez Cardenas. Your Honor, first let me apologize. I did log on the court.
I saw you.
But I had a situation that was going south in East Lansing. I got to run down there in person to try and put out a fire.
Right. We left this for last because we saw you and we thought either you're going to show up on Zoom or come back in person. So no worries. I don't know if we have an appearance yet, but we understand you're here on this case. We're here in this case of the PCC. We will need an appearance. This was set for 8:30. It is now 11:05. And it would appear that the defendant has failed to appear based on some of the representations. I don't see Mr. Cardenas Gonzalez in the Zoom courtroom. He's not in the physical courtroom. He was a co-defendant. The co-defendant has been bench warranted this time. Ms. Wilson, how we proceed?
Thank you, Your Honor. We're requesting a bench warrant on this file as well.
All right, Mr. Johnson, I don't know if you've had contact with Mr. Cardenas. What's your response?
One time, Your Honor, through his brother, who was co-defendant. I have not had contact, and the number that I had to contact him, or will contact him through the brother, I was unable to contact him, Your Honor. All right. So I'll issue at this time, I'll issue a bench warrant. It appears that council's had some contact with him, and I do remember at the PCC, there's indication that through the brother, there was some contact. He has not appeared today. So we'll issue a bench warrant and bond forfeiture for Mr. Gonzalez Cardenas Gonzalez. Yes, Your Honor, I'm gonna go do that appearance right now. All right. Anything else for the record in 24-01-803, Ms. Wilson?
Not for the people, thank you.
Mr. Johnson, are you all set?
No, Your Honor. Yes, Your Honor, thank you. Nothing further.
Thank you. And we figured out I had Washington as one of the officers. So I kept referring to I'd look down, I'd see Washington. I'm familiar with Mr. Johnson. So
Yes.
You are very speedy today. All right, this is. Mr. Holly's here. I think we need the other. So Felipe. This is Felipe, and then we need one on. That. And then Ms. Wilson, are you doing the second?
I am.
Ollie case? And then is Mr. Austin on that case?
Yes.
All right, so we're on the record in docket 24-01-841. That is people of the state of Michigan versus Terrence Hawley. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Austin.
Good morning, Your Honor. Jared Austin appearing on behalf of Mr. Hawley. He is present with me at council table.
Sir, you are Terrence Hawley, is that correct? Thank you. This is the time set for a preliminary examination today. Ms. Wilson, how we proceed?
Thank you, Your Honor. I am ready to start the exam. I would be requesting a continuance at the end of it. The complaining witness in this matter is not here today. It's my understanding he is currently homeless and we've had a difficult time tracking him down. So I would just be requesting a continuance at the end of the proofs presented here today in order to track him down.
All right, and then you are presenting witnesses today?
I am, Your Honor, yes.
All right, Mr. Austin, any response to we have not seen the first witness. You're going to have a witness, but there's going to be a request for adjournment. I'm sure that's been shared with you at some point.
I believe I did. Yes.
All right. So Mr. Austin responds.
Yes, Your Honor. Thank you. I mean, they can certainly start the exam today, which would fulfill the 21-day obligation. I would be inclined to oppose the people's request for an adjournment. Would it be the court's preference for me to address that now or at the end of proofs?
Probably the end of proofs, but as the motion to adjourn is requested. So I will I'll leave it for you to tell me when to invoke the sequestration order. Somebody comes in that shouldn't be listening to another person's testimony. And with the understanding that there may be a request for adjournment at the end of proofs today, is everybody ready to proceed with the pre-roll?
I am, Your Honor. Thank you.
Mr. Austin.
Yes, Your Honor, other than sequestration, which I think the court indicated it would be ordering.
Right. I ordered sequestration. I'll invoke sequestration based on attorney's statements or any indication that that another witness is watching another witness testify. So you may call your first witness, Ms. Wilson.
Thank you, Your Honor. The people will call Officer Stelges. I think he's on the bench part. Yep.
Officer Stelges, you can come up here. I don't know if I said that name correctly. You can stand right there. Please state and spell your first name and last name for the record.
Tyler Stelges, TYLER STELLJES.
All right, Officer Stelges, please raise your right hand. Do you solemnly swear affirm, tell the truth, the whole truth, nothing but the truth under penalty of perjury?
I do.
All right, go and have a seat. The microphone is for the court recorder, so please project as best you can. And Ms. Wilson, you may proceed.
Thank you, Your Honor. Officer Stelges, where do you work?
City of Lansing Police Department,
And what is your position?
police officer.
What are your general duties?
General patrol duties, make arrests, investigate crimes.
And were you working as a Lansing police officer on June 19th of 2024?
Yes,
What were you wearing?
a full marked police uniform.
Okay, and is that the uniform you have on today?
Yes,
And were you on foot while you were working that day?
I was in a patrol vehicle and at some point I did exit my vehicle. Yes.
Okay, and is your patrol vehicle issued by the department?
Yes,
And does it have any markings on it?
it does.
What are those markings?
Lansing Police.
Okay. Now on that June 19th date, were you dispatched to the area of 6250 South Cedar?
Yes,
And is that in Lansing,
yes,
Ingham County,
yes,
state of Michigan?
yes.
Okay. And generally speaking, what were you dispatched there for?
Unarmed robbery.
Okay. And did you end up going to that location?
Yes.
What happened when you arrived there?
I observed a victim with a walker. He had pointed at Mr. Holly, stated that is the man that took my phone.
Okay.
Object to hearsay, Your Honor, unless it's not being offered substantively and just for the effect that it had on the officer as a listener of that information.
Ms. Wilson, objection hearsay.
That's exactly what I'm offering it for effect on the listener.
All right, so it will not be used substantively because it's not being offered for the truth. We'll allow it for effect on the listener as he was done in the investigation. So the objection is sustained, but the hearsay is allowed for not for the truth matter, for not being offered for the truth. And you may proceed. I believe the officer's already testified
Yes.
that that's what prompted part of the investigation.
Yes, Your Honor, thank you. So after that individual pointed out the other individual, what happened?
I observed Mr. Holly standing near where the individual was pointing. I exited my patrol vehicle. I started advancing, walking towards Mr. Holly, told him to stop, identify myself as the police, at which point he said he did not do anything, and he started running from me to flee from the police.
And did you pursue him at that point?
I did.
And can you tell me a little bit about how that went down?
I chased after Mr. Holly all the way around an apartment building on the outside of the building. I observed him run into the building of 541 East Edgewood through the front door. When he ran into the building, I lost sight of him. A female had pointed that he was upstairs, at which point I ran to the top floor and I observed Mr. Holly on the top floor. He was ordered to get on the ground to comply with us. He did not. Force had to be used to take him into custody, at which point he was taken into custody on the stairs.
Okay. And once he was taken into custody, did you perform a search of him?
We did.
And did you find anything on his person?
I found the victim's cell phone in his back pocket.
Okay. And that person that you arrested,
Here, I'm just going to make an objection. I think there's a foundational objection. He said he found the victim.
Yeah, it should just be a cell phone, correct?
Cell phone, that's fine. Yep.
All right. So with that understanding and clarification, the objection sustained. Clarification that a cell phone was found, since we don't have any testimony from the victim yet, but a cell phone was found on the person of Mr. Holly. You may proceed, Ms. Wilson.
Thank you, Your Honor. And that person that you arrested, did you get a good look at him?
Yes.
Would you recognize him if you saw him today?
Yes.
Can you point him out and describe something he's wearing if he's present today?
He's wearing a blue jumpsuit with long red nose.
Thank you, Your Honor. Thank you. I request the record to reflect identification.
Request the witness identification of the witness of the defendant for purposes of identification for preliminary examination of Mr. Austin.
Without objection.
Without objection, the witness has identified the defendant for purposes of prelim. Ms. Wilson, you may proceed.
Thank you, Your Honor. Now you identified the individual that you just pointed out as Mr. Holly. At some point in your investigation, did you learn his name?
Yes.
How did you learn that?
When he was booked in at our jail.
Okay, I have nothing further for this witness, Your Honor.
All right, Mr. Austin, any cross-examination?
Morning, officer. So you arrive on scene and Mr. Holly is still on scene. Is that correct?
Correct.
Okay. And you said he made a statement about that he didn't do anything, and at some point he took off running. Is that correct?
Correct.
Okay. And when he took off running, Had you told him to stay there at that point, or did he take off running before you had given him any type of commands?
He was given commands to stop police
And was that by you or other officers as well?
by me.
Were there other officers on scene with you at that time?
There was.
Okay, which officers? Were there?
Officer Cena.
And did he join you in this foot pursuit of Mr. Hawley?
Okay.
And you said at some point force had to be used to take Mr. Hawley into custody, is that correct?
Correct.
Was that inside the apartment building?
Correct.
Okay. And when you say force, was that like some kind of a tackle?
Yes.
Okay. And did that result in Mr. Hawley kind of going down the stairs?
Correct.
And when you were telling, was it you or Officer Cena that told Mr. Hawley, stop police?
I did.
And that's because you wanted him to stay there, is that correct?
Correct.
And was that detention for an investigation based upon what another witness told you? Or was it your intent to place him under arrest and then in custody at that time?
It would be based upon my investigation.
Okay. So you were just wanting to see if Mr. Hawley would talk to you about what may or may not have happened, is that correct?
Yeah.
Thank you, Your Honor. I have no further questions.
I need to redirect Ms. Wilson.
Briefly, Your Honor, thank you. So Officer Stelgis, you're at the top of the stairs, is that correct? With Mr. Hawley?
Correct.
And
Yep, the third floor.
The third floor, okay. And at that point, are you giving him any further commands?
He was told multiple times, stop, just to stop.
And what was he doing once you gave him those commands?
He was just argumentative.
Okay, so was he complying with your commands?
No.
Okay, nothing further, Your Honor.
Right. May this witness be excused from the people, Ms. Wilson?
You may, Your Honor, thank you.
Mr. Austin.
Yes, Your Honor.
Witness, thank you for your appearance. You're all set. Thank you. Any further proofs from the people, Ms. Wilson?
Yes, Your Honor, the people call Officer Antonio Cena.
Officer Cena, you can come up here. And please state and spell your first name and last name for the record.
Antonio Cena, ANTONIO CENA.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Right, have a seat. The microphone is for the recorder, so it doesn't amplify your voice. So do the best you can to project. Ms. Wilson, when you're ready.
Thank you, Your Honor. Officer Cena, where do you work?
For the City of Lansing Police Department,
What is your job position?
police officer.
What are your general duties?
Currently, I'm assigned to the Lansing Police Traffic Unit, so I also do respond to 911 calls for service, conduct traffic stops, and enforce criminal law.
Okay. And were you working as a Lansing police officer on June 19th of 2024?
Yes.
What were you wearing while you were working?
I was wearing a fully marked City of Lansing police uniform and driving a fully marked City of Lansing police car.
And is that uniform the one that you're wearing here today?
It is.
Now on that June 19th date, were you dispatched to 6250 South Cedar?
Yes, I was.
Is that in the city of Lansing,
It is.
Ingham County,
Yes, ma'am.
state of Michigan? And did you eventually end up going to that location?
Yes.
What happened when you got there?
Units were dispatched to a priority call, dispatch tone priority for an armed robbery that had occurred. I was currently assigned with a partner officer, Tyler Stelgis, that day.
And once you arrived there, what happened?
We witnessed a male matching the description of the accused that 911 dispatch had given us. We exited our patrol cars, identified ourselves as police officers, and the accused ran on foot.
And when you say you identified yourself as police officers, what did you say?
Lansing police, stop, come here.
And what happened after that?
He ran away.
And did you pursue him at that point?
Yes, we did.
Where did that lead to?
It led to an apartment complex, the street number, I can't remember. We ran around the apartment complex, into a front door, up 3 flights of stairs.
Okay. And at some point, did you make contact with that individual in the apartment complex?
Yes, we did.
And was there an arrest made?
Yes,
And after he was arrested, was a search of his person conducted?
yes,
And was a cell phone found?
yes.
Okay. Now, after the cell phone was found, were you able to determine who owns that cell phone?
Yes.
And how were you able to determine that?
As other officers were taking the accused into custody, I took it upon myself to interview the victim. The victim was able to articulate.
Your Honor, I'm going to object to hearsay.
Response.
Thank you, Your Honor. I am seeking to admit this evidence under MRE 1101B8, which specifies that in a preliminary examination in a criminal case, hearsay is admissible to prove ownership, value, possession of, or right to use or enter property.
So this would just be as to ownership of the cell phone.
That is correct.
Any response, Mr. Austin?
Yes, I have no objection if that's the limited scope of what it's being, offered for. Obviously, it can't extend beyond that into substantive elements beyond what's called for in that particular rule of evidence.
All right, so I'll hear testimony concerning the ownership of the cell phone. With that understanding, the objection is overruled pursuant to the request under the statute for ownership purposes. You may continue, Ms. Wilson.
Thank you, Your Honor. Now, Officer Sino, without telling me anything that the complaining witness might have said about how he lost the cell phone, can you tell me how you were able to identify who owned the cell phone?
The owner of the cell phone was able to articulate facts about the item that the general public would not know, such as battery life, wallpaper imaging, and what was on the phone.
Okay, and did that match the cell phone that you had recovered?
Yes.
Okay. And did the individual say whether or not he had given anyone permission to take that phone?
He did not give any permission.
Okay, nothing further, Your Honor.
All right. Mr. Austin, any cross-examination?
Sure, thank you. Morning, officer.
Good morning.
So, and so as I understand your testimony correctly, you said you were assigned with or working with Officer Stelgis that day, is that correct?
I was.
So does that mean the two of you arrived together at the same time in the same patrol vehicle?
Yes.
And you said you had, it was either you or Officer Stelgis told, who you later learned to be Mr. Hawley, stop police or something along those lines. Is that correct?
That's correct.
So Mr. Hawley was still on scene when you two arrived, correct?
Yes.
And that interaction at that point that you were having with Mr. Hawley, was that based upon the description that you were giving from whoever called this matter in, or was that based upon your conversation with any other witnesses?
No other witnesses.
Those is based upon the call description?
Yes.
And was it your intention to have Mr. Hawley stay there that he could be detained to further investigate the matter, or were you intending on placing him at rest right there on the spot?
At that time, no, he was only going to be detained and questioned.
Thank you, Your Honor. I have no further questions.
Any redirect, Ms. Wilson?
After the people, Your Honor, thank you.
May this witness be excused from the people?
You may, Your Honor, thank you.
From the defense?
Yes, Your Honor.
Mr. Cena, thank you for your, Officer Cena, thank you for your appearance today. You're all set.
Thank you, Your Honor.
Any further proofs today, Ms. Wilson?
No, Your Honor, I would just request that continuance.
That's Officer Cena. And Mr. Austin, you can, any objection you have to the request for adjournment at this time, you can make a record.
Your Honor, I would oppose the people's request for an adjournment. There has been no indication as to one, whether or not they've had any contact with the complaining witness or what attempts have been made, if any, to ascertain his whereabouts or to get in contact with him. This is not a situation where they've had some kind of contact and some kind of indication that maybe he was unavailable today, or he'd indicated to them that he was going to be here, and now we don't have him here. That might be a different matter, but we haven't had any record evidence presented today as to either of those. If they had some difficulty in securing him, it appears from my reading of the police report, Your Honor, it gave them some additional information that he could be reached, and they've had ample opportunity to, I think, ascertain his whereabouts or his intentions. So absent hearing any type of good cause reason as to why he's not here, or any attempts that they've made to reach him or to ascertain his whereabouts, I would oppose the request for an adjournment.
Thank you. Ms. Wilson, response.
I can certainly make a record as to my attempts. The complaining witness did provide a CMH counselor that he was seeing that he could be reached through. I contacted that CMH counselor, who advised that he was under the impression that the complaining witness was in custody. I found that he had been in custody at one point, but was recently released. He is homeless. Additionally, the CMH individual has had some recent health complications, so has not been in contact with a lot of people recently. Additionally, I did find a phone number that I thought may be the complaining witnesses. I attempted to reach him at that phone number. Turns out it was not the complaining witness's phone number. I've reached out to the detective bureau to ask them to employ their resources to try to track him down. To my knowledge, that is being reviewed as a request. So that's kind of where we're at here. Again, this individual is homeless. It's kind of the nature of these things. Obviously, if we get a continuance and that individual does not show at the next hearing, then certainly that's another issue. But we have started the exam here today. I have made efforts to track this person down. I'm just requesting a continuance to make further efforts.
Any response, Mr. Austin?
Your Honor, I would just still maintain my position that there hasn't been a sufficient good cause shown for the adjournment, or any reason to believe that the complaining witness will be found, or he will show up and appear and participate in the proceedings. So I maintain my objection of the
Thank you.
request.
The court finds that there is good cause to adjourn the proceeding. Two witnesses have testified concerning, at least they responded to the investigation concerning this file, and it's been started. It appears that the prosecutors made efforts to attempt to locate the victim through a third person, and then through some contact in regards to whether he needs to be writ out. So I will grant I will grant a good cause adjournment at this time, with the understanding that also Mr. Holly's looking at another file that's just been bound over. So we have some question as to whether incarceration level at this time, but I think one adjournment would suffice. And so we will adjourn to
July 19th at 1:30.
July 19th. That's 2 weeks.
That should be sufficient. Thank you.
So July 19th at 1:30 for the continuation of the preliminary examination. Anything else for the record in docket 2401-841, Ms. Wilson?
Nothing to people. Thank you.
No, Your Honor. Thank you.
All right, you're all set, Mr. Holly. We'll see you on that July 19th date.
Judge, do you want me to grab Evans?
Grab Evans, yeah. That's a good idea. We'll find Mr. Palmer. So. That ends your time with us, Mr. Austin. Both of those files. And now we can see if you see Mr. Palmer from your office.
It's his turn.
It's his turn.
Okay.
And Mr. Sartz is this afternoon on Mr. Wallace, is that correct?
Yes, that is correct.
That's correct. All right. I think we took that, we had some or most of your cases today, Mr. Austin.
Yes.
That's it. But it's good for us. It's lucky for us. We know where to find you, right?
Lucky me.
Yeah. Lucky you. All right, this is Mr. Cardenas, Gonzalez Cardenas. I don't know if we're gonna see Mr. Gonzalez or Cardenas Gonzalez or Gonzalez. I think they're in the wind. I don't think we're gonna see Mr. Lavoy.
I double checked and I got the date wrong. It's the 18th, so we've got a little bit more time
All
to
right.
try to track him down. But yeah, no, I think he's gone again.
I want to know how he made 6,000 cash surety. That's pretty impressive. For anybody, I mean, but
For anybody, I don't have 6,000 lying around.
no. Or I mean, it's not a surety. I think he cashed.
Yeah.
I don't think he
Yeah.
was. Because nobody's going to insure that.
No.
Nobody
his
I know.
record,
I mean,
yeah.
no, based on his record, nobody I know, but he made it.
What are we doing on Mr. Evans?
Running it.
That is Mr. Who are your witnesses on that?
That will be Officer Ebright, Officer Boysen, and Officer Rotuno.
Sure.
Copy the complaint.
I was gonna ask you to do, it, and I remember what happened the last.
Let's see Mr. Palmer anymore.
I wonder if Mr. Palmer went down to talk to his client.
He might have.
Because the
He
first
might
time
have.
he tried to talk to him, they didn't have any rooms available.
Right.
Right.
Yeah, which is frequently the case.
Yes, I just wonder if he.
I didn't see him anywhere else on the floor, so.
He might be talking to his client, and so
His coffee
Megan's
is
running
here,
into him.
So in his bag, so I'm guessing that's probably where he is. I don't usually see him without his coffee.
Yeah.
I did notice he got a bigger coffee cup.
Good day, Judge.
You too, Mr. Austin. Thank you.
Allergies giving you fits today?
No, I think I have whatever Andrew has. He's out and I had a low fever last night, so.
Keep your little germs on that side.
Yeah.
Judge, thank you so much.
Thank you.
I don't know why they copy it with everything else I copied, but I sure didn't.
So that's we have Mr. Evans here.
Yeah.
Because it's kind of a hit or miss.
Now I think this little boy make that 6 million. He made it twice.
There's money someplace. There's money someplace in that.
Well, if you use by that whole thing when we all thought that out at the same time.
Mr. Palmer, were you downstairs talking to your client?
I was.
That's what we thought. We're having him brought up.
Yes, that's good.
I don't think I like Thursday now. It's my whole days.
Throws you off a little bit. I think they should just put it on a Friday. Just make everybody
all
happy.
holidays should
Give
be
everybody a
Monday or
3-day
Friday.
weekend and then, I'm not gonna lie, I didn't realize that we were open on Friday. I didn't realize that we were open today, otherwise I would have taken today off. And then by the time I realized it, I was like, why do I have court on the holiday? Yep. Oh,
I do believe the courts are the only thing downtown working.
I think everybody else took it off. Yeah, I think so. Yeah.
Thanks. Oh, Lordy.
What's that?
The new court rule that makes all the exams non-public at bind started today. And if they don't request a transcript at the exam, it's non-public and they have to get it through the 30.
Yeah, we don't necessarily agree with the reading of that, but well, I'll let the higher ups duke it out over that.
Yeah, I think that's the thing.
Yeah.
To do. Well, I think that, just to be clear, I think that's a separate issue, right? I'm gonna address that regardless of which, I don't want you to make a decision based on. All right, that's a separate issue. So, there. I will address that issue too. So that's not what, I don't think that's gonna do. You need a second to talk to your client, Mr. Coleman? I think he's just trying to make his decision. I'm sorry, I'm not standing up. I think he's just trying to make his decision about running versus waiving. All right, let's give you a few minutes to talk about it and then come get me when you're ready, all right? Yes, yes, sir.
All right.
Sometime to talk a little bit. Thank you.
Just knock on the door when you're ready.
Yeah.
Sounds good.
And Rob, I
Yo.
just want to make clear the offer was waive on the PWID and the strangulation and the DV plea to the possession of the DV.
Right, but
Yes.
you're saying waive and it stays a possession, not a PWID. Yes?
No, it waives as a PWID.
Oh, yeah, then never mind.
Okay,
We're
all right.
All right, I mean, if it was if it was waive as is,
Yeah.
then I get it.
Okay, yeah. So then we're ready.
There's no.
soon. Yes, Judge, we're ready whenever you get there. Thank you.
All right.
You can be seated. So we're on the record in docket 24-01801. That is people of the state of Michigan versus Brandon Evans. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Palmer.
Thank you. Robert Palmer, the Public Defender's Office, on behalf of Brandon Evans, the gentleman who is seated or standing to my right.
And sir, you are, I'm sorry, that's right. And sir, you are Brandon, and I've got some Valdez Gilson Evans. Is that correct?
Yes, sir.
Thank you. This is the time set for preliminary examination. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I have my officers here today. We're ready to proceed.
All right. Are there any preliminary matters to be brought to the court's attention from the defense, Mr. Palmer?
I would just ask for sequestration of witnesses. Other than that, I have nothing further.
So I'll order sequestration of witnesses, but leave it to counsel to invoke it. If you see somebody who shouldn't be in the courtroom, who should not be watching somebody else's testimony. Ms. Wilson, you may, if there are not any other preliminary matters, you may call your first witness.
Thank you, Your Honor. People call Tyler Ebright.
Officer Ebright, you can come right up here. And please state and spell your first name and last name for the record.
TYLER EBRIGHT.
That's Tyler Ebright, correct? Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Please have a seat. The microphone is for the court recorder, so please project as best you can. Ms. Wilson, you may proceed.
Thank you, Your Honor. Officer Ebright, where do you work?
Lansing Police Department.
And what are your general duties?
I'm a patrol officer.
Were you working as a Lansing police officer on June 14th of 2024?
I was.
And what were you wearing?
Full police uniform.
Is that the same uniform you have on today?
Yes.
All right, and Your Honor, just request the record to reflect that there are two police officer patches on the side of the uniform and a shield on the front.
Without objection, the record may so reflect.
Without objection.
Thank you.
Your Honor. Now, Officer Ebright, on that June 14th date, were you dispatched to 3325 Porterville Drive?
Yes.
What was that in reference to?
Domestic assault.
And did you end up going to that location?
I did.
When you arrived, did you make contact with anyone?
I did.
Who?
That would be Khadija.
Okay. And what was Khadijah's relation to the call?
Khadija was in the hallway and she had allegedly been assaulted.
Okay. Did you observe anything notable about her?
I did. She was struggling to talk. It sounded like she had trouble breathing.
Okay. Did you obtain any information about Khadijah's relationship with her assailant?
I did. That they've been dating for 6 years.
Okay. And did you learn when the incident occurred?
Yes, it was the morning of around 1 to 2.
And do you recall what time you responded?
Can I see my police report?
You can, Mr. Palmer, do you have a paper copy? Because I don't have a
I
paper
do.
copy. Thank you.
Never mind the highlighter.
No, that's fine. Your officer permission, or Your Honor, permission to approach.
You may approach.
All right. Officer Ebright, if you can give that a look, read it silently to yourself and let me know when you're done. All right. And is your memory sufficiently refreshed?
It is.
And around what time did you respond?
7:09 in the morning.
Okay. Now, Your Honor, at this time, I'd ask to admit the statements from the victim to Officer Ebright pursuant to MCL 768-27C. It's the people's position that all of the elements have been met here. The statement, it was about an assault, that it was made near the time of the infliction of the assault. It sounds like it was a couple hours afterwards. It involved a domestic relationship. These two had been dating for some time. It was made to a police officer, Officer Ebright, that said that he was working as a police officer and he was wearing his full officer uniform. And I believe the circumstances, it provides some indica of trustworthiness. Officer Ebright just testified that he noticed that the victim in this matter's throat was hoarse and was having trouble talking and trouble breathing.
Thank you. Any objection to the hearsay statements coming in pursuant to the domestic violence Michigan Court Rule 768.27C, Mr. Palmer?
Your Honor, I would just ask as a standing objection, but I acknowledge that the foundation has been laid to proceed under that statute.
Thank you. There's a standing objection as to the violation of the Confrontation Clause and allowing these hearsay statements in. With that understanding, the foundation for 768.27C has been laid, as counsel indicated. The statement seems to purport to narrate or describe or explain the infliction or threat of physical injury upon Ms. Kadeem Ahmed. The statement was made at or near the infliction or threat of physical injury of the death. It looks like 5 hours difference, 4 or 5 hours difference. That the statement was made to a law enforcement and involved a domestic violence situation in which the domestic indicated, or the victim indicated, that they'd been in a dating relationship for 6 years. With that understanding, 768.27C, the foundation's been met, and you may provide hearsay statement for bindover purposes. Ms. Wilson.
Thank you, Your Honor. Officer Ebright, what did the victim say happened?
She said she was in her apartment with Mr. Evans and another female named Kinky. She said they were all eating chicken and her and Mr. Evans wanted some ranch for the chicken at the same time. Confrontation started over that, where Mr. Evans then strangled Ms. Ahmed for 2 minutes, where she struggled to breathe, and then he bear hugged her, picked her up, flipped her around where her feet were in the air, and then slammed her head first into the ground.
Okay, and when you say that he strangled her, did she describe how he did that?
May I see my police report?
You may. Thank you. May I approach, Your Honor?
You may.
All right. Officer Ebright, just give that a read, and once your memories refresh, please let me know. All right, is your memory sufficiently refreshed?
Yes.
Okay, and how did the victim say that Mr. Evans strangled her?
She said he used one hand to wrap around her throat.
Okay, and at some point did the victim request medical attention?
She did.
And at some point was she transported to the
She
hospital?
was.
Okay. And did she provide the full name of the individual that she said assaulted her?
She did.
What is that name?
Brandon Evans.
Did you provide a physical description of him?
Did I provide it?
Did she provide?
She
physical-
provided a description.
Okay, and was Mr. Evans there at that time?
He was not.
Once you received information about who the possible assailant was, what did you do?
So she actually told dispatch the identity of the subject.
Okay. All right, I have nothing further, Your Honor.
Thank you. Any cross-examination, Mr. Palmer?
Thank you, Your Honor. Good morning, officer.
Morning.
I just have a couple of questions. You indicated that you were dispatched out there, out to this residence on Barterville. This was roughly 7 a.m., I think you said. Does that sound right?
7:09.
7:09. And the incident supposedly happened between 1 and 2 a.m. Is that right?
Yes, sir.
Or at least that's what you were told, right? Is that a yes?
Yes.
Fair enough. Sorry, I do the same thing. And you didn't obviously personally witness the incident, right?
Correct.
You appeared at the scene for the purposes of collecting information from whatever individuals you could talk to about it, documenting what you found, and then turning it over from there, correct?
That's correct.
And you indicated that although Miss Ahmad, when you talked to Miss Ahmad, she indicated that she was in a lot of pain, but you indicated in your report that you did not locate any markings of any kind on Miss Ahmad. Is that right?
That's correct.
All right. Is that unusual that a person would undergo an assault without having any markings, or is that common?
In my experience, it is fairly common.
That's common that there's no markings whatsoever?
Yes.
Including a strangulation that takes place for 2 minutes. That's common that there would be no kinds of markings on the throat or anything like that.
I've had it both ways in my career.
Okay. And tell me about, there is also, you indicated in your report that you were dispatched actually to that same address twice between the time of the assault, but around 1 or 2 a.m. and the time you arrived at 7:09. Is that right?
That is not right.
All right. So if you put in your report, oh, I'm sorry, officers were dispatched. I apologize. Officers were dispatched, maybe not you.
Correct.
Is that correct? All right, fair enough. Sorry, that's my mistake. And you learned that morning that officers had been dispatched there for a fight with multiple subjects, right?
Correct.
Did you find any evidence of that? When you were,
question.
Yeah, fair enough. When you arrived on scene, did you see any evidence of a fight with multiple subjects or anything like that at the scene?
At the time I was there, no, I did not.
All right. And there was, and as part of that, there was the dispatch was that there was a female with a knife. Were you ever able to determine who that person was?
I was not.
And then officers were dispatched back again at 4:30 in the morning. Is that right?
That sounds correct.
And again, that dispatch, as far as you've indicated in your report, was for screaming and an argument going on in the hallway. Is that right?
Yes.
Were you ever able to determine what that was about?
No, so I asked dispatch about both those calls, and dispatch informed me that the officers at that time couldn't make contact with anybody.
Okay. And I realize that you were not there. You don't know what steps were taken to try to identify what these calls were in regards. Is that fair to say?
Yes.
Sorry, if I could have just 1 second, Judge. And I guess the other question is when you arrived and were speaking with Miss Ahmad, you were advised, at least by Miss Ahmad, that there had been at some point 3 people there, that being Miss Ahmad, Brandon Evans, and a person named Pinky. Is that right?
That's correct.
And at the time you arrived, Pinky was also, whoever this Pinky individual was also not there. Is that right?
Correct.
Did you ever learn whether Pinky was involved in this incident at all?
She didn't mention. She said she woke up at some point and she heard people on the phone. I believe one of them was Pinky.
All right. Was there ever any indication from Miss Ahmad that Pinky tried to prevent her from calling the police? Do you recall that?
I don't recall.
Would reviewing your report help refresh your recollection? Your Honor, may I approach?
You may.
Your Honor, actually, I'm going to object here as to relevance. Nobody is charged here with interfering with a police report. This is a third party that was never made contact with. Additionally, I think this is outside of the scope of 27C. The infliction of the violence has passed and it's not by the individual which Ms. Ahmad had the dating relationship with. So I think it's hearsay.
Response, Mr. Palmer.
Well, Judge, this is exactly the problem with 27C, is that, we're stuck with this very limited scope when clearly in the report, there's indications that other people were involved, that there were other things going on. And then, we show up and we're only allowed to talk about specifically what it is that this one witness said to this officer, but there's no real way to cross-examine that. And there's clearly indication that other people were involved, other people were trying to influence in some way that the witness's testimony, except we're not allowed to talk about that.
But I'm going to allow it as to impeachment. I think it comes in as impeachment as to some of the statements that were made, and also impeachment as to what the officer wrote down in relation to that. So I will allow it as impeachment. The objection is, understand the objection. It's sustained in part because it's not being offered for the truth of the matter, but it is being offered for impeachment purposes and I'll allow it. Yeah, so that part of the objection is overruled. Mr. Palmer, you may proceed.
May I approach you?
You may.
Officer, I'm showing you the same report you looked at. I'm talking about sort of the bottom third of this statement there. Take as much time as you can. Are you all set?
Yes.
Thank you. All right, officer, I guess I'll just ask again, was there any testimony that that Miss Ahmad was in any way interfered with regards to her ability to contact police or anything like that?
Yes, so once she woke up and she heard the people on the phone, Pinky was on the phone with Mr. Evans and Miss Ahmad tried to call for help and Pinky covered Miss Ahmad's mouth with her hand.
All right. And okay, I have no further questions, Your Honor. Thank you.
Any redirect of Ms. Wilson?
No, Your Honor, thank you.
May this witness be excused from the people, Ms. Wilson?
You may, Your Honor, thank you.
Mr. Palmer?
Yes, Your Honor, thank you.
All right, without objection, the witness is excused. Thank you for your appearance today. And Ms. Wilson, you may call your next witness.
Thank you, Your Honor. The people will call Officer Rotano. Thanks.
Officer Sean Rotano. Officer Tony, you can come up here and stand right in front of me and please spell and state your first name and last name for the record.
Sean, S-E-A-N, Rotuno, R-O-T-U-N-N-O.
Okay, please raise your right hand. Do you solemnly swear or affirm, tell the truth, the whole truth, nothing but the truth on a penalty of perjury?
Yes.
All right, go ahead and have a seat. The microphone is for the court recorder, so it doesn't amplify your voice. So please project as best you can. Ms. Wilson, when you're ready.
Thank you, Your Honor. Thank you, Your Honor. Officer Rotano, where do you work?
Lansing Police Department.
And what is your position?
Police officer.
What are your general duties?
Investigate crimes, perform arrests, respond to calls for service.
Were you working as a Lansing police officer on June 14th of 2024?
Yes.
And how were you dressed on that date?
In my full police uniform that I'm seen wearing now.
Okay. And Your Honor, I just asked the record reflect again, the two patches on the shoulder that indicate police and the badge on the front.
Without any objection, the record may so reflect the officer's uniform at being worn today.
Just to be clear, no objection.
Okay, thank you.
Thank you, Your Honor. And Officer Rotano, on that June 14th date, were you dispatched about to the location of 3325 Bardaville Drive?
Yes.
Did you actually end up going to that location?
Yes.
And what was your purpose for going there?
That was some sort of a fight complaint, whether it was a fight, domestic, troubled subject. I don't remember exactly how dispatch coded the call. But essentially, Officer Ebright responded first. I was there second, looking for a potential accused in, again, some form of an assault.
Okay. And were you given some sort of description of the person you were looking for?
Yes. Dispatch prior to my arrival, they provided that the accused name, based on caller information, was Brandon Evans, that he was wearing a red shirt with ripped jeans, as well as that they located an active arrest warrant for him out of Ingham County.
Okay. And when you arrived at that Bardaville Drive address, did you meet anybody there?
I circled the drive and then I located later who we identified as Brandon Evans. Behind, I don't remember the exact address because there's like 4 apartment complexes around Bardaville. But between the first one to the north, which is right behind the liquor store in that corner.
Okay. And is that still in Lansing?
Yes.
Ingham County?
Yes.
State of Michigan?
Yes.
Okay. And how were you able to identify that person as the person you were looking for?
So there was a call that through his SOS picture prior to getting out when I observed the subject, who again we later identified as Brandon Evans, had jeans that they were not actually ripped, but they had like frays of clothing, but that was by design. So it looked like they were ripped from someone who wasn't paying close attention, as well as the subject who I made contact with had a red shirt. It was not wearing it, but it was draped over his shoulder.
Okay. And when you say SOS photo, can you just clarify what that means?
Secretary of State in our lien system.
Okay. So is that like his driver's license photo?
Yes.
Okay. And the person that you saw there resembled the individual in that driver's license photo?
Yes.
Okay. Now, did you end up talking to that person?
Yes.
And what happened when you made contact with them?
So the person, I asked if he was Brandon, he denied being Brandon. We kind of had that same back and forth that I did believe he was Brandon and he kept denying it. I asked for an ID or anything to prove to me that he wasn't him, so I could essentially leave, because if he wasn't the person I was looking for, I had no more business talking to him. At one point, backing up to the call information, there was information provided by dispatch to me that our caller said that Brandon may have had a knife on him. So in the midst of that conversation, while I did still believe I was talking with Brandon, I hadn't been able to physically verify that by any form of ID or anything. I told him I was going to pat him down because I did believe that 1, he was Brandon, and that 2, he did have a weapon on him. As I took a step forward to pat him down, he kind of bladed his shoulder to me, stuck his hand out. He didn't say anything, but it was kind of an indicator to me like, hey, he was trying to prevent me from going forward. And based on his physical stature, as well as the fact that we were in one of the farthest northwest corners of the city that had a physical altercation occurred, backup was coming from a distance away. So I waited, I continued to talk to him. When other responding officers arrived, based on the warrant and his behavior, we decided to place him under arrest at that time.
Okay. And once he was arrested, was the search of his person conducted?
Yes.
Was anything found?
Yes, in his front left pocket, there were 2 bags of a white powdered substance. One looked, this was like a whole bag of that white substance, and then the other bag had looked like individually wrapped, I guess, packages, for lack of a better term, of that same white substance.
Okay. And how long have you been a police officer?
3.5 years.
3.5 years. Have you investigated any narcotics situations before?
Yes.
About how many would you say?
Honestly, I couldn't tell you.
Okay.
North of 10, but
Okay.
I'm sure it's more than that.
All right. And did that substance in those bags look like anything to you?
Particularly, again, unknown substance, a lot of those, it's when someone has an unknown substance, it's usually an indicator that it's a narcotic, but until you test it, you don't really know. I've had it go both ways, to be completely honest, where it was narcotics and where it looked like narcotics, but after it was tested, it turned out not to be.
Okay. And was anything else found on his person?
There was a knife found. And then I do believe, I did not find it myself, but Officer Boyson found in his ID confirming he was Brandon Evans.
Okay. And that person that you arrested, do you see him here today?
Yes.
Can you point him out and describe something he's wearing?
Blue suit with long dark hair, mustache and a small beard.
All right. Your Honor, I request the record reflect identification.
Any objection to the witness identifying the defendant for purposes of prelim? Mr. Palmer.
No, not for exam today, Judge. Thank you.
For purposes of prelim, the witness identified the defendant. You may proceed.
Thank you, Your Honor. Now, Officer Ortono, once you took those substances out of Mr. Evans' pockets, what did you do with them?
I gave them directly to Officer Boyson.
Okay, nothing further, Your Honor.
Cross-examination of Mr. Palmer.
Thank you, Your Honor. I guess I just have a couple of questions, Officer. You received the description of the suspect from someone else, is that right?
Yes, from our dispatch, who would have received it from a caller.
Okay. And so your interactions with the individual who you've identified as Mr. Evans, that was based on, it's not based on something you personally saw, right? It's based on information you received from dispatch. And all right. And when you showed up, you found some white powdery substance in his pocket, among other things.
After the arrest was performed, yeah.
Sure. After. Did you yourself did you test that substance in any way?
I did not test it myself.
All right. So like you're familiar with what a true narc is?
Yes.
You did not perform a true narc.
I did not perform the true narc.
All right. And actually, I have no further questions, Your Honor. Thank you.
Thank you. Ms. Wilson, any redirect?
No, Your Honor, thank you.
May this witness be excused from the people?
You may, Your Honor.
From the defense?
Yes, Your Honor.
Thank you, Officer. You're excused. And Ms. Wilson, you can call your next vote.
Thank you, Your Honor. The people will call Officer Bridget Wilson.
Right. Officer Boyson, you can come up here and stand in front of me and spell your first name and your last name for the record.
BRIDGET
That's Officer Bridget Boyson. Is that
Yes,
correct?
yes.
Please raise your right hand. You solemnly swear or affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury.
I do.
Please have a seat. The microphone is for recording purposes, so it goes directly to the court recorder. So please project as best you can. Ms. Wilson, when you're ready.
Thank you, Your Honor. Officer Boyson, where do you work?
Lansing Police Department,
And what is your job title?
patrol officer.
What are your general duties?
Going to dispatch calls when they come out, patrolling the general Lansing area, things like that.
Okay. And were you working as a police officer on June 14th of 2024?
Yes.
How were you dressed on that date?
In the uniform you see right now.
Okay. And Your Honor, again, just for the record, there are 2 patches on the side that identify police there, and there is a badge on the front.
Yeah, well, any objection to the court indicating that the officer is in the LPD uniform with the patches on the left and the right, Mr. Paul?
I have no objection whatsoever.
All right, thank you. The record may so reflect, and Ms. Wilson, you may proceed.
Thank you, Your Honor. Now, Officer Boyson, on that June 14th date, were you dispatched on or near the area of 3325 Bardaville Drive?
Yes.
And what was that in reference to?
Officer Rotuno asked for a backup unit to help him with the subject, and I went out there to help.
Okay, and so I'd like to fast forward a bit in the call. Did you assist in arresting someone at that time?
Yes.
And was that near that Bardaville Drive address?
Yes.
And that was in Lansing?
Yes.
Ingham County?
Yes.
State of Michigan?
Yes.
Okay. Now, did you get a good look at the person that you arrested?
Yes.
Would you recognize him if you saw him today?
Yes.
Do you see him here in the courtroom?
Yes.
Can you point him out, describe something he's wearing? Okay, Your Honor, I'd request the record to reflect identification.
Identification made for purposes of a preliminary examination. Any objection, Mr. Palmer?
No, Your Honor. Thank you.
For purposes of identification, the witness, for purposes of prelim, the witness has identified the defendant. You may proceed, Ms. Wilson.
Thank you, Your Honor. Officer Boyston, after the individual was arrested, did you assist Nick search of the person?
Yes.
Did you find anything on his person?
No.
No? Okay. Did anybody else find anything that you saw?
Yes. Officer
Okay, and was anything given to you?
Officer Rotuno handed me 2 bags of a white powdery substance.
Okay. Were you able to identify the person that was arrested?
What do you mean?
Were you able to learn his name?
Yes.
How did you do that?
There was a wallet in his back pocket and an ID, and the photo on the ID matched him.
Okay, and what was that person's name?
Brandon Evans.
Now you said that Officer Rotuno gave you white powdery substance, is that correct?
Yeah, they were in plastic bags.
Okay, do you know about how many he gave you of those plastic bags?
2.
2. And how were they packaged in the bags?
One was just a bag with powdery substance. Another one had 14 smaller bags within it and a black bag that I couldn't see through, all in a bigger plastic bag.
Okay. And at some point, did you weigh those items?
Yes.
Do you recall the weights?
I recall that the one that didn't have any other bags within it, that one was 10 grams. And then I did weigh the black bag, or sorry, the one that had like the black bag and the 14 individual bags. That one, I believe, I'm sorry, I actually don't fully remember.
That's okay. Would redoing your report refresh your recollection?
Yeah.
All right. Permission to approach, Your Honor.
You may.
All right. Officer Boyson, if you just want to take a look at that, read it silently to yourself. Let me know when you're done.
So.
1 second.
Yeah.
No, you're okay. Are you done reading?
Yeah.
Is your memory sufficiently refreshed?
Yeah.
Okay. Now, having read that report, what was the weight of the other baggie?
Together, it would have been, I weighed them separately and pulled them out separately, but together it would have been 10 grams.
Okay. And at some point, did you test the substance?
Yes.
And how did you test them?
I used our TrueNarc machine.
Are you trained in using TrueNarc?
Yes.
And what was the procedure you used to test these narcotics?
So the TrueNarc machine, you turn it on, you always run a self-check just to make sure the machine is running properly. I did that. It said that it passed the self-check. Then you hold the TrueNarc machine up to the substance. There is a little nub on one of the sides that produces a laser. You want to hold that up to the substance so the laser goes through the packaging. Hold it until it tells you what, like either gives you an answer of what's inside, or it says like it couldn't test it.
And what was the response for these substances?
I said cocaine.
Cocaine. And was that for all of the substances that you tested?
Yeah.
Okay.
Yes, sir.
No, you're okay. Was there something with this particular TrueNarc machine that was maybe off on that date?
Yeah, the clock on it was 6 hours. I don't remember behind or ahead, but it was 6 hours off. I know that.
Okay, and is that something, based on your knowledge of TrueNarc, is that something that would impact its ability to test the substance?
Not that I'm aware of.
Okay. How long have you been a police officer?
2.5 years.
2.5 years. Have you investigated any narcotics before?
Yes.
Okay. I have nothing further, Your Honor.
Cross-examination, Mr. Palmer.
Thank you. Good morning, officer. I guess let me just start with the TrueNarc machine. You indicated that it was off one way or the other, and I guess it doesn't matter, but it was off by 6 hours. Is that right?
Correct, yep.
Is that something that can be like, is that, if you know, is that something that's like manually set, or does it somehow sync with the internet, or how does that work?
Yeah, so I actually asked our evidence people like how that works, and he said he had to contact the company to make sure to reset it. So I don't know if it was like a computer, like within the chip itself. I don't fully know. He didn't seem to fully know himself, so.
Fair enough. Now, you indicated that you ran some sort of a, can't remember what you called it, to be honest with you. I'm gonna call it a self-diagnostic. Is that?
Self-check. Yep.
Self-check. So the self-check is run to verify that the TrueNarc test or device, I'm sorry, is operating properly. Is that right?
Yes,
And it came back and it said it was operating properly,
it said it passed it, yeah.
but it nonetheless, it remained off by some period of time.
Yes.
All right. And you, and let me be clear about this, I'm not suggesting that you in any way did anything wrong here, but as far as you could tell, that test operated correctly, right?
Yes.
But it still ran with the TrueNarc off in some way, correct? In other words, it's all the time is off.
Yeah.
And so by the same token, let me ask it this way. Is there a report that's generated by the TrueNarc? In other words, does it just say on the screen, this is cocaine, or does it somehow generate some sort of a written report or receipt or lab data or anything like that that says?
Yeah, I think so on the backside, if I remember my training correctly, but I know that's not something like I would have access to. It's something that I think like evidence or the administrators of the TrueNarc machine would have evidence to, or sorry, access to is what I meant to say.
Understood.
But I know like I don't personally have access to that.
All right. And I guess to be clear, I think you said this, but I just want to make sure I understood you. You said that you did not personally find the narcotics on Mr. Evans, but you witnessed Officer Rotundo remove those from Mr. Evans and hand them to you?
Yeah, he pulled them out of his pocket, placed them down because he was pulling everything out of his pocket, then picked them back up and handed them to me.
Got it. And there was 2 bags, right?
Yeah.
Were both of the bags in the same pocket?
Yes.
All right. And then within one, so if I understand correctly, one of the bags had just an amount of powdered, what you believe to be cocaine, right?
Yep.
The other bag then had 14 smaller bags and 1 big bag within a larger bag?
Yes. Yep.
Well, let me ask you this. Did you take any personal statements from Mr. Evans?
No, I did not.
Thank you, Your Honor. I have no further questions of witness.
Can you redirect Ms. Wilson?
No, Your Honor, thank you.
May this witness be excused from the people?
You may, Your Honor.
May this witness be excused from the defense?
Yes, Your Honor. Thank you.
All right, thank you. Witness, you're excused. Further proofs of Ms. Wilson?
No, Your Honor, thank you. The people rest.
Any proofs today, Mr. Palmer?
No, Your Honor. Thank you.
Motion for bind over, Ms. Wilson.
Yes, Your Honor, thank you. The defendant's currently charged with 2 felony counts, the first being strangulation. We heard from Officer Ebright earlier today that he responded to that Varnaville address, and the individual identified as, I believe, Khadijah, I cannot remember or know how to pronounce the individual's name, but the victim in the matter met with Officer Ebright and explained the circumstances under which she was assaulted and that testimony came in through 27C. She identified Brandon Evans as an individual which she had a dating relationship with, who was the individual who strangled her. She described that as Mr. Evans using one of his hands around her throat and that her breathing was restricted. Additionally, Officer Ebright testified here today that the victim was notably hoarse when he was speaking to her and was having trouble breathing. She was transported to the hospital based on her injuries. So as to strangulation, I believe the elements have been met. As far as identification goes, Officer Rotundo and Officer Boyson both identified the individual sitting here in the room today as Brandon Evans, who was the individual the victim stated had assaulted her. Additionally, the defendant is charged with 1 count of possession of cocaine. It is the people's position that this charge should be amended to a possession with intent to distribute. It seems clear that the defendant possessed that substance. It was in his pocket. The substance tested positive as cocaine, understanding that the true narc test was off by some time. But Officer Boyson here testified today that to her understanding of how the true narc machine works, it has no impact on its ability to test a substance. He knew he possessed it. It was in his pocket. There is circumstantial evidence here that he knew it was a controlled substance. He actively resisted being searched when Officer Rotono attempted to search him, which is indicative of knowledge of contraband on your person. Additionally, we have testimony here today that the cocaine weighed somewhere in the amount of over 10 grams. And one of the packaging was packaged into individual 14 little small bindles. I don't think it takes a lot of mental gymnastics to understand that that's pretty indicative of an intent to deliver those, as individual packaging is relatively well known as being the way that things are distributed amongst users. So I would be requesting that that possession charge be amended to a possession with intent to distribute of cocaine.
Thank you. And the pack code for that, I have, my understanding is 333.7214A4.
I have 333.740112A4. And that's less than 50 grams.
Less than
Yep.
50. So 333.7.
74012A4.
So that you're requesting an amendment of count 2.
Yes, that is correct.
All right. Response to bind over, Mr. Palmer.
Thank you, Your Honor. Let me be clear, I'm not suggesting by any means in my comments that Ms. Wilson has done anything wrong by any stretch of the imagination, but this is why these cases are maddening. It's because there is clearly much more going on here, and because we are proceeding victimless, there is no ability for the defense to raise or address these issues. What we've heard is that the officers were called out twice to the same address, sometime between the alleged assault and the time they came into contact with my client, roughly 6 or 7 hours later. At one point, they're called out there to according to the officer, they're called out to a report of a fight between multiple subjects in the lobby and a female screaming. At another point, they're called out for a female with a weapon. And then, but because we're going here victimless, we don't get to talk about that. I think it certainly calls into account the trustworthiness of the statements that are made here. I think it is absolutely a possibility that there is, the officer indicated that he did not witness or did not personally see any injuries to this individual. I think it absolutely calls into context the trustworthiness of the statement. There was some dispute about something, apparently. We don't know who was involved. We also know that from the officer's testimony, even though it wasn't admitted as evidence, but rather impeachment evidence, I guess, there was some evidence that there was this other female who somehow prevented the complaining witness from contacting the police. I think all of that. And then, of course, what we have is that we have a complaining witness who has not shown up. And I think all of that absolutely calls into account, or it calls into question the credibility of the statements that were made to the officers and introduced here under 27C. It is, I know it's the state of the law. It's sort of hard to fathom how it is, but it's the state of the law. With that regard, Your Honor, I would ask that the court not bind over on count 1. With regards to count 2, again, Judge, I understand the request for the possession with intent to distribute. I would suggest to the court that I don't think that there's been enough of a showing to suggest that it's anything other than possession. I acknowledge that there is the testimony is that there's been 14 individual bags, but we've not heard anything about there's nothing in the evidence today to talk about cash that was seized, to talk about phone records or a phone dump, to talk about a statement made by my client. There is simply testimony that the cocaine was found, that some amount around 10 grams or more was found, and it was bagged into 14 different bags, which were then put into one big bag. You know, I guess my argument is it would seem to me that there would need to be some corroborating evidence. If I go into Meyer and buy a case of water, I am not in possession of water with intent to distribute water. It just means that I purchased it as a case in whatever it is, 48 or 50 bottles, as opposed to one giant gallon jug. What I'm getting at here, Judge, is that we don't have any other testimony to corroborate that Mr. Evans was attempting to deliver this substance, as opposed to he just purchased it that way. I will fully admit that there is absolutely sufficient evidence to suggest a possession. There's certainly no, I don't even really have anything to say to that. But the idea that it's possession with intent to distribute, again, Judge, I acknowledge why the prosecutor's making that argument. I'm saying that I don't think that the burden has been met. I'd ask that the court not bind over on those two.
Thank you. Response?
Briefly, Your Honor. While I certainly understand the defense counsel's frustration with 76827C, I'm not arguing that it's not frustrating. As he said, it is the state of the law. That's just something that's going to have to come up the legislature. But I would recognize that defense counsel said that he wasn't allowed to get into the two prior calls. He was. I did not object until we started talking about the statements from Pinky, or the statements from the victim about Pinky. So that did come in under 27C and everything like that. So I do think that there's sufficient evidence here, even though there was no markings. The victim had a very hoarse voice, as Officer Ebright testified. That's corroborating evidence to a strangulation. As to the possession with intent to deliver, there is case law out there that weight is enough. There doesn't need to be a phone dump. There doesn't need to be statements. Certainly those are helpful, but that's not required, especially to a probable cause standard here. I do think that the evidence that's been submitted is sufficient for the court to bind over on that, that modified count, and I would request bind over.
Thank you. The standard for preliminary examination is probable cause being the second lowest standard in criminal law. I had the opportunity to listen to the testimony of Officer Tyler Ebright, Officer Sean Rotana, and Officer Bridget Voisins as witnesses in regards to the file, and find that on June 14, 2024, the date has been shown by probable cause evidence. This all occurred at 3325. The address, it's actually the complex. So I don't know if it was the actual, actual state of the apartment, but it is that 3325 Barterville address in the city of Lansing, Ingham County. I find that date, venue, and location have been met. Identification was made through various individuals, but it was identified. Mr. Evans was identified as the person at the scene by the 6-year relationship, by the hearsay of Miss Ahmad, Miss Khaja Ahmad, and then Tyler, Officer Rotana, who is the one who found the cocaine, is the one who made the identification, identified the person in court. So I believe ID has been made at a probable cause level. The offense is made, and I do understand the frustrations for the 768.27C, the hearsay that came in regards to Miss Evans' testimony or Miss Ahmad's testimony to Officer Ebert, indicating the nature of the assaultive behavior. The 6-year dating relationship made on her behalf identified Mr. Evans as the person who was made the assault. She indicated it was one hand wrapped around her throat. It was for 2 minutes at a time. There did not seem to be anything physically indicative of that assault. However, she was hoarse. That was audibly noticeable. But Officer Ebright indicated that was the nature of the assault that was referred to him, and that's enough for the probable cause level So I will bind over on count 1, assault with intent to great bodily harm, less than murder. Count 2 is the more interesting court account legally. It was there's no doubt it was in possession. There's no doubt that he was that it was identified and it was tested as true narc as a controlled substance of cocaine. There does seem to be some time lag difference on the machine, but the officer said she saw it, she tested it. And so at a probable cause level, I believe that's sufficient for bind over. The question is the amount, because it raises, the amended count 2 raises the amount to possession with intent to deliver controlled substance of cocaine at a probable cause level. I will indicate that both bags together weigh 20 grams or 10 each. So bag 1 is 10 grams, count 2 on count 1, and 10 grams on 10 grams. So 2 bags were taken out, 10 grams each for narcotics purposes. In the second bag, there were 14 bags individually packaged. And I believe that at 10 grams, the whole thing was weighed at 10 grams. That is sufficient for bind over on intent to deliver because of the packaging and the amount of weight. There is some credibility issues concerning whether the trier of fact will find it in that relation, but I believe that is indicative at a probable cause level of not possession, but possession with intent to deliver, mostly because of the packaging purposes and the weight. It was tested as true narc tested, and therefore I believe at a probable cause level, count 2 is bound over as amended with possession with intent to deliver, which is 333.701A4. Yeah, 333.7484, and I will bind over. Count 3 will follow as a misdemeanor. I will bind over count 2. So the examination was held on today's date, and it's bound over as charged on count 1. Count 2 will be bound over on the possession with intent to deliver at a probable cause level, and that's pursuant to 333.7401 A4. Anything else on the record and for this bind over on counts 1 and 2, 3 to follow on this matter, Ms. Wilson?
Yes, Your Honor, briefly, it's 74012A4.
12A4. So on the motion for bind over, anything else, Ms. Wilson?
Not for the people, thank you.
Mr. Palmer.
I don't have anything regarding the motion for bind over. I do have one very brief bond issue.
All right. So before I sign the bind over, Mr. Palmer, you can be heard on bond.
Thank you, Judge. I guess I'm just asking for clarification, or I guess a slight modification. Mr. Evans was in jail on an unrelated child support matter. He was supposed to be released yesterday because, as I understand it, he's on a personal recognizance bond in this case. The reason he remains in custody now, at least as I understand it, is because JSG, the tether company, has been trying to contact Khadijah Ahmad to verify an address so that they can create an exclusion zone. And at least what Mr. Evans reports to me is that JSG advised him yesterday that they've not been able to get in touch with Miss Ahmad. So they're at this time unable to provide a GPS tether for Mr. Evans, which means that essentially Mr. Evans is now sitting in custody, sitting in jail because Miss Ahmad, who I'm not going to readdress it, but I've already raised my credibility concerns with. Miss Ahmad is apparently not answering the phone or whatever, however they're trying to contact. What I would ask the court to consider is that, and to be clear, I'm not even asking to have the GPS tether condition removed. What I would ask is that rather than having an exclusion zone, that the court convert that to just a GPS tracking tether so that Mr. Evans could be released. I do think it's a little bit unfair for Mr. Evans to continue sitting in custody just because this complaining witness, who has not appeared for preliminary examination, continues to sort of either she's not provided correct information, which may absolutely be the case, or she's purposely denying it so that he sits in jail. I don't know which, and I'm not suggesting one or the other, but I do think it's a little bit unfair, that situation. So I'm asking that the GPS tether be converted.
Thank you. Ms. Wilson responds.
Thank you, Your Honor. It's my understanding that the GPS tether is victim notification if possible. Sometimes JSG doesn't pay attention to the if possible, so I don't know if they need to be reminded of that, but if it's not possible and they've made their attempts, then I think that they have their answer.
All right. I think Mr. Palmer raises a fair issue here concerning, so I'm going to convert the bond, I'm going to modify bond to be GPS for monitoring only. Since we don't have a zone notification as to the victim, I can't indicate, there's a continued no contact order with Miss Ahmad. And the GPS for monitoring purposes will let us know how close he gets to Miss Ahmad, and that in and of itself will be the police report concerning this matter. But since we don't have a locale for Miss Ahmad at this point in time, we can't tell Mr. Evans where to go, and that's not fair. So let's do bond modification for GPS monitoring purposes only. Bond was initially set at the 5,000 PR. I'm not going to change that. So we'll say that was by the arraigning judge. And so the modification is for monitoring purposes only. Anything else for the record in 24-01-801? Ms. Wilson.
Not for the people, thank you.
Mr. Palmer.
No, Your Honor, thank you.
All right, I will sign the bind over document at this time. Mr. Evans, your time in district court is done on this file. You'll be on the circuit court where you'll get your next date from your attorney. Okay, sir? You're all set. Thank you for your appearance today. And then the request is made for transcripts, and that's being signed right now.
All right. All right. You should be getting out today. Can I still talk to you for such a seat? Yeah, real quick. What's up? Yeah, I want to. Just something. This one. Well.
Do you get my email? I'm trying to figure out spelling. Yeah, I have to check it. I have to check the police report. It looks like it's spelled both ways in the report because nobody really figures it out. So I'll check it out. Email you back.
Gotcha.
Yep.
I was just trying to make
Yep.
sure I had my spellings.
Yeah, that's pretty. Yeah, let the dog out.
He did not test it. He said he had it.
Or at least try, because this morning she was up, but. All right, so Mr. Walls this afternoon.
That's correct,
Okay.
yep.
Good luck, all right?
Yeah.
Yep, all set.
Mr. Palmer, Ms. Wilson, I'll email JGS with the change.
Thank you.
Thank you. All right, Mr. Palmer, you're all set here, huh?
Yes, Judge. I think I'm gonna go home. Gotta go deal with my kid.
How old is that kid?
She turns 18 on Sunday.
Oh, fine.
Yeah. No, she wants me to take her to get her nose and her belly button pierced.
Yeah, that sounds about right.
Yeah, that's awesome. She also wants a tattoo. She wants us to get matching tattoos. So.
I got a tattoo when I was 18.
Did you?
Yeah.
I've had them since then.
And I had multiple piercings starting when I was 14.
Here's the thing. She's a good kid.
Yep.
I don't really. She's gonna get a tattoo whether I agree to it or not. So I'm like, what am I doing?
And
Right.
I mean, she's not gonna have a belly button for piercing forever.
I know.
So might as well do
It's
it
a
while she's
fact.
got it.
I know. Well, she wants she and I to get a tattoo like
Okay,
together, like a
yeah.
father-daughter tattoo, I guess.
My
Right.
oldest and my husband have that.
Oh.
Yeah, I mean, she's a daddy's girl. She's
We
a,
refer to Megan as MM for Mini Michael, my husband.
yeah, mine has been that kid like ever since she was 2 or 3 years old. The minute I get up to go, if I got to run to the feed store or something, she's got her boots on. She's like, "I'm going with you, Dad." Right? Like she just immediately goes. So yeah, she's absolutely
That's
a mini.
my oldest is like that still today. Even at ridiculous months pregnant, when I had her fit, she went up north to go deer hunting on opening day. I'm like, Meg, honey, you know that we're like 40 minutes away from the nearest hospital that can deliver this baby. You are due in a week and a half.
Yeah.
I'm not a cesarean, it'll be fine. I'm like,
it's fine.
Okay.
Yeah. Yeah.
I was a nervous wreck until I got back because I was just like, so does anybody want to watch a video on how to deliver a baby?
All right, guys, take care. I'll see you.
Yeah.
Have a good weekend.
Okay, Missy Moo. What you need?
I just think I'm gonna wait.
I think that's probably a wise decision. Alrighty then. I'm gonna go in the office and try to get the sentencing crap done for Monday. I'm surprised
fun.
Lauren Sutter hasn't emailed me yet. Because I got that on whatever day we were here last at 4:30 and clearly I didn't do it. Because I was walking out the door.
Yeah.
So has Taylor answered you?
She has. She says she has no strong feelings either way, so I'm gonna email her back and say, well, I would like to adjourn. So.
Okay, I'll wait for this day.
Yep.
But I'm not calling a jury. I need to tell admin to call it off.
Okay.
Okay. Good day.
Yep.
Even over it.
This afternoon should be pretty quick.
I should be able to leave at 4 now too. On a Friday, so nice holiday weekend. Case numbers make my life easier, woman.
Oh, sorry. Thank you.
Like, why? I just did interest of justice, you weren't specific.
Yeah, sorry. It was like a global thing.
That works.
Yeah.
He's in custody.
He is in custody, but not on this.
Okay.
Just picked up.
She's just pulling files and going to jail last night.
Oh,
Like,
okay.
don't put him on there.
Yeah.
Organize this and this.
Yeah, and I'll email Yang and let him know that I
Okay.
sent that too.
We're going to jail. I got it.
Hold on.
Hey, how you doing?
I'm all right. How are you?
Good. Mr. Wallace is here, so
Cool.
get through the morning docket, all right?
Oh, yeah. Did all of your exams run?
None of them ran.
Oh, that's nice.
Just two of my clients are in custody. Obviously, Mr. Jackson, I didn't bring over.
Right.
I didn't bring over Ms. Allen either, but none of the witnesses, not even the cops show up generally for validating. We just decided. I thought for sure she was brought over,
Mhm.
and I told the court that, and then I go down with the nine, is like, they apparently they set her off to another court, so. Witnesses didn't show up for Mr. Bill Bay either, so. Setting aside a dismissal at that point, reissue and
Right.
recharging only for the witnesses not to show up. Yeah, it was a strange morning that way, where I had two people in custody and none of them were brought over.
Yeah.
Well, sorry about your guy.
Oh, no
It's
worries.
Totally my fault.
No problem. No problem at all. And the big one was gonna be Amory, because I had two with him and he didn't show up at all. So
Oh, fun.
one had some. Been an outburst in front of Judge Ward last week.
Oops.
Judge Ward nearly held him in contempt. At least that was the sense I was getting
Mhm.
from her. She was quite concerned about his behaviorisms. Are we in for the afternoon?
Yep.
Oh, okay.
All right.
You can be seated. All right, so we're on the record in docket 24-01518. That is People of the State of Michigan versus Rashad Walls. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Sarks.
Good afternoon, Your Honor. Jacob Sarts, Fourth Assistant Public Defender here on behalf of Mr. Wallace. He's present at council table. He's seated to my right.
And sir, you are Rashad Walls, is that correct?
Yes, Your Honor.
All right, thank you. This is the time set for preliminary examination today. I'm sorry, this is the time set for first a motion and then a preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe it's just set for a motion and then we're going to set a date for the preliminary exam.
Okay.
After the court rules on the immunity petition.
All right, and so I am in possession of the people's petition in support for application for statutory use immunity pursuant to 780.701. Ms. Wilson, you may proceed, or if you want to rely on your brief or make a brief summary of the motion, the petition you filed.
Thank you, Your Honor. I largely rely on what I've provided the court in my petition in brief. I believe that the circumstances in this case are under the purview of the statutes and interest of justice. And I think that it would be a disservice not to permit this. So I would be requesting that use immunity.
You're requesting statutory use immunity pursuant to MCL 780.701, and then you've indicated your understanding of the statutory use of immunity. That would go to this file. It doesn't go to any other. It's not a blanket immunity. It only goes to the testimony concerning this file.
That's correct, Your Honor. And my understanding is that it's for the limited scope of what I've outlined in my petition, namely the discharge of the firearm and the circumstances surrounding that. That is my understanding.
All right, thank you. Mr. Sart's response to the petition.
Thank you, Your Honor. I would note I did not include a written response here. I will just reply orally to the prosecutor's motion at this time. I will just simply note that this is the type of issue that, based on my research, seems to fall squarely between the prosecutor and Your Honor. I would note that the defense can raise objections in situations where there's potential issues with due process. Simply for the issues of issue preservation, Your Honor, I will just state that Mr. Walls, of course, refutes the allegations and the verified statement. And for the issues of issue preservation, Your Honor, I would object on the grounds that perhaps having immunity might incentivize the witness here to possibly embellish, alter, or somehow change your testimony in some way beyond a way that would be easily discernible through impeachment, simply because the witness no longer has to fear any possible prosecution based on her testimony, albeit, of course, these orders do reserve the right for possible charges in situations of perjury or something along those lines. So there are some limited guardrails in terms of that, Your Honor. So simply for the issue of issue preservation, I will object on behalf of Mr. Walls as a potential issue due to the witness possibly embellishing her testimony. And I'll try to phrase that as a due process issue.
Thank you. Ms. Wilson, anything else or any response?
Just brief response. As Mr. Starks pointed out, this use immunity is contingent upon honest and truthful testimony. And additionally, it's not a blanket immunity, as I stated. It's specific to what I've outlined in the petition. So I don't think that there's a risk of embellishment or anything of the sort here, but I understand the defense's blanket objection. And I further request the court grant the use immunity.
Thank you. Seeing the petition and then being somewhat familiar with the statute 780.701, Mr. Sartz is correct that this was more of a belt and suspenders approach to hearing the motion first and then sending it for prelim, so that everybody had the opportunity to make a record on the matter. Based on the Army, because I'm going to sign the petition in support for application for statutory use immunity pursuant to 780.701. This is not blanket immunity as indicated on the record. This only goes to the events that have indicated in the petition. And I think that cross-examination can take care of some of the issues. Mr. Sartz is correct. There is somewhat of enticing the witness to testify in any manner they choose to, with the understanding that the prosecutor withholds any perjury or any type of obstruction charge in this matter. But I will sign the petition on today's date, and then we will set it for prelim. And I would think the framework is a couple of weeks out, or we're 2 weeks out or 4 weeks out, I think.
Those are the options.
Yeah.
I would request 4 weeks. I believe that the complaining witness in this matter is entitled to conflict counsel per getting immunity if she
Right.
wishes, in order to properly explain to her rights and the scope of the immunity petition.
And Mr. Walls is not incarcerated at this time, so this goes towards, I think, erring in the side of the 4-week date for purposes. But I know that Mr. Sartz is in trial, so or has some trial dates. So let's get a date and we can confirm that with the schedule.
Thank you, Your Honor.
August 2nd at 1:30.
August 2nd at 1:30. Does that work for your schedule, Mr. Sartz?
Yes, Your Honor. Thank you.
So August 2nd at 1:30. All right, so we will entertain the preliminary examination, full testimony. Mr. Sartz, please let the prosecutor know if you need any additional information or discovery on the matter, and we'll set it for that date. Anything else for the record in 24-01518, Ms. Wilson?
After the people, thank you.
Mr. Sartz.
Thank you, Your Honor, and thank you for noting the discovery issue. I would just reinforce our standard request from our appearances as relates to any additional benefits or deals offered to the complaining witness here as it relates to her testimony for exchange beyond what has already been disclosed.
All right, and that's just a reminder that anything that the witness is going to testify to should be brought to Mr. Sartz's attention. All right, so we'll see everybody back here on August 2nd at 1:30. Thank you, everybody, for your appearance.
Thank you.
I did.
Probably wish a copy of
Yes,
it.
please.
Thank you, Mr. Sartz.
Mr. Sartz, did you need a copy of the order for immunity?
Yeah, please. Yeah, if you just email to me, that's fine. I'm working with.
Okay. Were you trying to print something? Yeah, I was just trying to. No, oh, there we go. Okay. I heard it trying to go. I was like, it had paper in it. That noise means the order is thinking about it. Do you want to make 2 copies and give one to Mr. Sartz, please, and one to Ms. Wilson? It'll save us a little time later on today.
All right.